or what has been modified in terms of this judgment of the Honorable Supreme Court by law converting the amount given under love and affection as loss of estate from 50 to 15. Consortium का 40 ही रखा है. Expenditure on last rights have been increased 1,000. So from 1660 it comes to 1630. But I have not decided the arguments raised by the non-senior counsel which were not pleaded in the writ petition. I have observed it that whatever has been pleaded beyond pleadings is not being considered. इसमें I have dismissed the writ petition.
Great question.
You will get the order after submission.
Yes.
Yes, Rohit.
Please, Your Lordship. Lordship, Lordship, we are the unemployed person of the area, Lordship, and with the cooperation of the local body, Lordship, the petitioner has constructed a small stall over the land, Lordship. And Lordship, that the land upon which the stall of the petitioner is situated, that is the common village land, Lordship, in which occupation of the village lord. It is respectfully submitted before this honorable court, Lordship, with the consent of the Gram Panchayat, Lordship.
Why are you here?
Lordship, my appeal is pending before the honorable FC, Lordship. That is not, even a single hearing is not.
When was it filed?
On 24th of February, Lordship.
24th of?
February 2025.
20. So,
Lordship, the first.
It is completely misconceived. How can you rush to the High Court after 2 months and say that there is delay in adjudication?
Lordship, kindly, Lordship, on 30th, 21st, there was the first hearing, Lordship, but the hearing was not done before the FCR.
You have to tell the state. We don't know. We can do nothing.
Lordship,
how the system works.
Lordship, also there is a आज की भी date पड़ी है, Lordship, but इसमें 20/5 की पड़ गई, Lordship, and the revenue department is going to disturbing us continuously, Lordship.
You see, problem ये है कि आपका FC बैठता ही नहीं है.
Please, Lordship, that is the reason, Lordship.
मेरे को बताओ जरा, when has he sat? No, when was the case filed by you?
On 24th of February, Lordship.
24th of February.
Lordship. पहली hearing, Lordship, 21 मार्च को थी, वो भी नहीं हुई, Lordship. First hearing was 21st of March, वो भी नहीं हुई, Lordship.
21 मार्च को नहीं हुई,
फिर आज की पड़ी है, Lordship, वो 20 जून को दे दी, Lordship, जो आज की भी डेट पड़ी थी, Lordship. That has been postponed to 20th of June, Lordship. Now, Lordship, the Revenue Department is going to disturb us, Lordship, and the notice has been issued from the field कानून को.
आज मतलब
नहीं बैठेंगे,
भी नहीं छोड़ी.
आज भी नहीं होगी, Lordship, 20 की दे दी है, Lordship.
Ask the FC to assemble and hear the case. Why is he not hearing the cases? You ask him to go to his office, hear all the cases. Otherwise, I'll pass some order. We'll seize the power of this officer to act as financial commissioner. The quasi judicial authority. If this is, you see, his problem is there is an order of ejectment passed.
Yes,
he has challenged that order by way of either a revision or an appeal.
Revision, Lordship.
Before the FC. Now, on one hand, the FC is not entertaining the case. On the other hand, the authorities, they are pressing him hard to have the orders implemented.
Yes, Lordship.
Ask him to assemble wherever he is and hear the cases. आप उनको बोलो अपने जो आपने आर्ग्यू करना है वहाँ पे.
Lordship, some other counsel is there.
तो बोलो वहाँ पे जाएंगे अभी.
Lordship, नहीं तो eviction के order हुए, Lordship, हमारे eviction के orders है.
वो वहाँ पे करेगा. It is his job, not my job. Go and आपने वहाँ पे interim की दी हुई है ना application.
Please, Lordship.
Ask the officer to pass appropriate orders on the application. This way or that way. The court is not suggesting क्या करना. But you see, yesterday also there was a case listed here. वो भी FC का ही था, if I am not mistaken. और उसमें अगर 30 जिमनी ऑर्डर्स थे ना, तो 30 में से कोई 27 थे कि FC not available, FC not available, FC not available. फिर फायदा क्या मैंने एक जुडिशियल ऑर्डर में भी बोला है आपको कि अगर आपने नहीं बैठना है to amend the act. After that, give the power to judicial officers. We'll hear the cases. We'll decide the cases. High Court, our officers are not shying away from deciding the cases. लेकिन आपको जजों की पावरें भी चाहिए और काम भी नहीं करना, तो ऐसा तो नहीं हो सकता. So I don't want to hear the state. Perform, do your job, and report back to the court that the court of FC has assembled. Decide नहीं है. Not only this case. कितने cases जिसमें आज की तारीख है एंड करो, अदरवाइज वील एक्सरसाइज ऑफ सुपरवाइजरी जुडिशरी. बताओ जरा वहां पे करना. ठीक है, वहां पे पास ओवर किया है.
प्लीज लॉर्डशिप,
ये करेंगे कुछ तो जल्दी इजी है.
प्लीज लॉर्डशिप.
यस अजय वैद्य. यस प्लीज. Shri Sat Prakash, yes please.
The state is directed to place on.
Yes, Vaidya ji.
Lords, may kindly see. Lords, I have been granted one license for running Lords as 14S band, my lords. I have deposited entire my lord feces, and thereafter, my lords, by way of annexure P4. No, my lords, they have asked me to shift this band without any cause. My lords, they are saying that this band has to be shifted due to the pressure of the local MLA and my lords, other thing, my lords. This issue has been dealt by the Honorable my lords High Court by the my lords. Lords, may kindly have these two judgment, my lords. If my lords can see the judgment rendered by the Honorable Division Bench, my lords, I request my lords to have para number 5, my lords, at page number 8, my lords. And thereafter, this judgment has been rendered by the Honorable Single Judge also, my lords, last year, my lords. Same issue was before the Honorable Division Bench, my lords. Para number 5 may kindly be seen, my lords. So my humble submission, my lord, there is no.
आपको वेंड लॉट कब हुआ था?
ये 13 मई को हुआ है जी. 13 मई को, my lords, I have already. Please, my lords.
Put this. Learned AG accepts notice on behalf of respondents 1 to 4. List on dash instructions to response in the meanwhile. 23rd June.
Please, my lords.
In this karna notice in above terms till further orders. Operation of annexure P4 26/2025 is hereby stayed, and respondents to and parties to maintain status quo quadi. Liquor maintenance.
Please, my lords. Grateful, my lords. Grateful.
दोनों जिले हाथनामा है.
हाँ जी
वापस कर दो. हाथ में देना सर.
Please, I will.
टाइम दे.
ठीक है, please, my lords.
Yes, Shri Sat Prakash.
Compliance the order, my lord.
Pass over. Yes, please.
See, in this case, in fact, at least a partition was filed that went against me before learned assistant collector first grade. But also my objection is two. One, that the further Kabja Mocha has not been prepared, and we called it Naksha Alif. That has also not been prepared. Although the mode of partition says that possessions are to be kept intact, but those have been destroyed. Mainly that, in fact, is the reason why I'm in.
The order was passed on.
This was not now only. May also some. This was passed on 11 July 2024. But also it was reserved at Dharamshala. Then it was passed, and information was not given to us at all. This I have specially stated.
It's also a problem which almost every litigant is raising before the High Court. That you reserve the judgments, then you announce it on a date of your convenience, say that convey it. कल भी मैंने एक केस में रिकॉर्ड मंगाया था, नोटिस 1 से 4 के लिए सरकार, प्राइवेट रिस्पॉन्स को नोटिस रिटर्न फॉर डैश स्टेप्स इन ओनली, मिसलेनियस में करना नोटिस इन अबव टर्म्स till further orders the operation of the order passed by learned financial commissioner dated 14/7 dated 31 है सर,
क्या जी 11/7/2024 in revision petition number 195 of 2017 next period shall be maintained. Observe one status quo to be maintained by the party.
Status quo shall be maintained by the parties for the
Authorization.
For the land ministry. Jai Durga Stone Crusher. Yes, please.
Lordship, in this case, what has happened?
I'm being for short.
नहीं, आप किसके लिए? You are appearing.
She is with me only, Lordship.
Yes.
Lordship, may I have an extra P1 at page 18 for a moment? This is a communication dated 11th of April 2025, which says on so and so, meter tamper data being so and so, has been reviewed by the undersigned, and it was noticed as under. Prolonged failure so and so. Then they say provisional assessment is being made, and you deposit this amount. Section 26 of the Electricity Act says, once there is a provisional assessment, then objections are to be called from the respondents. And once they adjudicate the objections, then it culminates into a final assessment notice. In this notice, Lordship, they don't tell me how this is calculated, for what we from the Act. Lordship, may have section 26 for me.
26 or
126.
126.
May I pass on, Lordship?
An inquiry will be made.
Lordship.
To the matter who.
And still they tell you deposit this money, otherwise we are going to disconnect.
Yes, please read 126.
Lordship. Subsection 1.
That
If on
उससे आगे चलो.
an order of provisional assessment shall be served upon a person in occupation or possession or in charge of the place of the premises in such manner as may be prescribed. The person on whom an order has been served under subsection 2 shall be entitled to file objections, if any, against the provisional assessment before the assessing officer, who shall, after affording a reasonable opportunity of hearing to such person, shall pass a final order of assessment within 30 days from the date of service of such order of provisional assessment of electricity charges payable by the person. No person served with the order may accept such assessment and deposit the amount of tax.
फिर से पढ़ो.
Any person served with the order of provisional assessment may accept such assessment, that is the provisional assessment, and deposit the assessed tax with the licensee within 7 days of the service of the provisional assessment served upon him. Then 5 says, then they will have to adjudicate, and if they make an adjudication, then it goes in appeal under section 126. My submission in this matter is, they have made an inspection, not told me the inspection report, not told me the data on which 13,85,000 has been computed. Provisional assessment is there. I have a right to file objections. Still they say that you deposit, otherwise it will be disconnected.
What do you say?
Your Lordship, it is a provisionally assessed. They have every right.
The problem is that the people who are at the helm of the affairs, either they do not know the law.
Yes, you know.
Huh?
Correct.
Either they do not know the law or
How
they
to
are held
do
out
this
to
assessment?
assess these persons.
Yes, Your Lordship.
This order is perverse. On the face of it, it is perverse. The most, if the provisional assessment has been made,
It is provisional assessment.
just listen.
Yes,
The authority has to follow the mandate as is provided in 126(2).
correct, Your Lordship.
Only if a party succumbs or says that, okay, I agree to this provisional assessment, he or she may deposit the amount.
Yes.
कोई mandatory नहीं है. And the statute does not say that where a provisional assessment is made,
Correct, Your
the
Lordship.
party has to. So इसको quash करता है. You follow the procedure provided.
Yes, Your Lordship.
Follow the procedure. अरे खत्म करें इसको. You follow the procedure.
Yes, Your Lordship. This may be, I'll advise them that this will be a provisional.
No. 11/4.
They may issue a fresh provisional.
No. 11/4/25 will be quashed because you have done a provisional assessment.
Yes.
will provide him with that provisional assessment.
And no opportunity.
Ask him to submit response thereto.
Yes.
Then proceed as per law.
Yes, Your Lordship. Yes, Your Lordship.
Because notice, ma'am, exception.
Uh-huh.
Taking into consideration the issue involved in this petition, the same is being disposed of at this stage itself. The petitioner herein is aggrieved by a provisional assessment notice dated 11th of April 2025, appended with the petition as annexure
E1.
E1. Contents thereof are as under. यहाँ से यहाँ तक. Learned senior counsel for the petitioner has submitted that as per section 126 of the Electricity Act 2003, if on an inspection of any place or premises or after inspection of the equipment, ये सारा लिख देना, ठीक है? The assessing officer comes to the conclusion this person is indulging in unauthorized use of electricity, comma, he shall, अभी नहीं मिटा मना कर दो, ना कहना मैं अपनी कन्वीनियंस पे कर दूँ, क्या चीज? हाँ हाँ.
Only regarding Your Lordship, third paragraph.
Just a minute.
Second paragraph.
He shall provisionally
Please.
assess to the best of his judgment the electricity charges paid by such person or by any other person benefited by such use. The section further full stop. The section further provides that the order of provisional assessment shall be served upon the person in occupation or possession or in charge of the place or premises in such manner as may be prescribed, and the person on whom an order has been served under subsection 2 shall be entitled to file objections, if any, against the provisional assessment before the assessing officer, who shall, after affording a reasonable opportunity of hearing to such a person, pass a final order of assessment within 30 days from the date of the service of such order of provisional assessment of the electricity charges payable by such person. The senior counsel submits that the provisions of section 126, that the provisions of subsections 1 to 123, 1 to 3 of section 126 of the Electricity Act 2003 have been sent to a toss by the respondent, as annexure P1 has been issued in violation of the said statutory provisions. Now, senior counsel has submitted that in terms of the scheme of the statute, in case the assessing officer was convinced of an illegality or irregularity being committed, as is envisaged in subsection 1 of section 126, then the order of provisional assessment was it has to be served upon the person in occupation or possession or in charge of the premises, and an opportunity has to be granted to the person to file objections, if any, against the provisional assessment before final order of assessment is passed, and that can also be passed only after affording a reasonable opportunity of hearing. In the present case, the senior counsel has submitted that annexure P1 has been issued without providing any provisional assessment to the petitioner.
Your Lordship, second paragraph, they were granted opportunity, but third paragraph is not correct.
Just a minute.
Kindly have.
क्या लिखा हमने? Go.
Second.
Let me dictate the order.
Please, 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 Your Lordship.
To the petitioner, comma, without calling for any objections against the said provisional assessment from the petitioner, and without affording any opportunity to the petitioner.
Now you.
In fact, learned senior counsel submits that there is no provision in section 126 of demanding the deposit of the provisionally estimated amount. Accordingly, he prays that the petition be allowed as prayed for and the impugned order be quashed and set aside. The senior counsel appearing for the Electricity Board submits that in the light of the statutory provisions of section 126,
notices has been given, and
there is the notice.
Kindly see paragraph, second paragraph, Your Lordship. The above facts indicated that you are quality of malpracticing as inquiry will be.
Kindly,
You have made.
ma'am, please appreciate. Where is
वो मैं second paragraph I am appreciating your lordship.
Where is the assessment order?
You may make representation to
Against what?
in this regard.
Against what?
They might.
You see, please read the provision once again, ma'am.
Provision are correct. Your lordship.
Where is the provisional assessment?
Your lordship, this coming for the first time, there must be provisional assessment.
It has to be reflected from the order.
Yes, your lordship. But your lordship, they have granted time to file representation.
File reply in reply to what?
They can ask them.
Why should they ask them? Statutory duty of the authority to follow the mandate.
That is correct.
Locker लगे हुए electricity board के.
No, your lordship may have, if they might have been given.
No, sorry, no ifs and buts.
Then your lordship may grant me one.
Then what is
3 days.
Then what is the fun of serving advance notices to the learned counsel for?
It was supplied, your lordship, yesterday only. And
what is the purpose of serving advance notices? After you received the copy of the writ petition.
It was in the evening, your lordship.
And what? You had time to tell them in the morning to have instructions, ma'am.
No, your lordship.
Then this is no answer.
Then either it may be.
Otherwise, practice of giving advance copy to the parties.
That is correct, your lordship. That your lordship is very right, but they have given right to file representation.
Please appreciate.
But this second part of the
sorry, you are not understanding the issue at all.
I am understanding, your lordship.
Please appreciate. There has to be an act of omission of his.
Yes.
It has to get converted into a provisional assessment.
Yes, your lordship.
Provisional assessment will be by way of an assessment order.
Yes, your lordship.
Along with this particular letter, the provisional assessment order has to be supplied to the party.
Yes, your lordship.
He is to respond to the provisional assessment. He is not to respond to the covering letter. No. What is before us is a covering letter.
But your lordship, if they might not have filed that, and they
आपको 12 घंटे का एडवांस नोटिस किस लिए दिया गया था?
12 घंटे तो
what was your instruction?
It can't be in the night, your lordship. अगर ये 4 बजे हमें कॉपी दे रहे हैं, तो it can't be sent to your lordship the place.
तो मैं आपको आधे घंटे का टाइम देता हूँ, आप इंस्ट्रक्शन दें.
मैं ले लेती हूँ जी.
आधे घंटे बाद.
2 o'clock.
आधा घंटा मतलब 11 बजे.
Please, your lordship.
Grateful.
Otherwise, second part is incorrect, your lordship.
I am again saying, ma'am, please appreciate what is following from.
I am appreciating, your lordship.
Reply is not to be filed to a 4-letter.
Yes, your lordship.
There has to be a
proper communication of how assessment has to be done. Yes, your lordship.
Communicated. Now they will.
Yes, your lordship.
That provisional assessment.
I'll seek instruction whether that has been given or not, your lordship.
Is it reflected in the order? That is the problem.
Yes, your lordship. That is not there.
And there is a provision. इनको आपको provisional assessment देनी है. आपको इनको time देना है objections file करने का. उसके बाद आपको इनको time.
Then final order. Yes, your lordship.
सुनना इनको फिर final order आएगा.
Yes, your lordship.
कुछ इसमें है ही नहीं कुछ.
But I'll seek instruction whether any, your lordship, assessment is given to them.
Duration. हाँ.
I am sorry to say so, but whatever my understanding is saying that it's actually incorrect.
अच्छा. क्या हुआ क्या हुआ?
It's 15 production. As per my instruction, I spoke with the concerned DRO, Mr. Shisha.
हाँ जी. आपको किसने बोला कि डेट दे दी सॉरी?
Lordship, as per the instruction received from our client's lordship.
ये होता वहीं पे ऐसे ही है. ये तो जब आपने फोन किया होगा तब वो बोल रहा होगा कि हम बैठ रहे हैं.
This is what I was told.
No.
Or if my lord will kindly see the petition, he has not enacted any Jimmy order.
नहीं, जब इसने कोर्ट में लगा ही नहीं तो
लगा ही नहीं lordship.
क्यों नहीं है? Will he be coming to the court and making a false statement?
I am not saying so, sir.
Your officers, on the other hand, they are in the habit of making false statements to the courts. और ये भी अब आपको mislead, आपको तो नहीं मैं बोलूँगा, कोर्ट को mislead किया जा रहा है by saying so. Why should the court disbelieve a poor litigant who has gone to the office of the financial commissioner और वहाँ पे सवेरे बाबू ने बोल दिया होगा कि अगली तारीख पड़ गई है, साहब है नहीं. ये तो जब आपने फोन किया होगा तो उससे बोला कि नहीं मैं तो बैठ रहा हूँ. How many cases have been decided by him till now, till 10:40? Has the court assembled till 10:40? What are the timings of the court? कितने बजे बैठता है कोर्ट? इसको डेट दे दी 21, कब की डेट दी हुई है?
30 जून लॉर्डशिप.
30 जून.
I'm sorry, lordship, but as per my instruction, lordship.
मजाक है बनाया हुआ आपके एफसीज वगैरह ने वहां पे, लिटरली. अगर उसने कोई लिख के दिया हुआ है ना, लिख के भी नहीं दिया होगा गरीब को।
नहीं लॉर्डशिप, सो और केसेस में भी यही है लॉर्डशिप, अगर किसी भी डेट्स को
आप मैं इसको आई विल टेक इट एज द लास्ट केस, शाम को देंगे।
He may go right now.
नो नो, अभी क्या करना वहाँ पे, अगर उसने बैठ नहीं
I spoke to the concerned official. He may go right now and he will look into it.
नहीं, ऑफिशियल ने थोड़ी करना है केस, तो आपके ऑफिस
Secretary ने लॉर्डशिप, sorry, FC ने लॉर्डशिप,
को बोल रही हो, जब सबको टाइम दिया 2 बजे का, 2 बजे बैठे,
उनसे बात करिए।
जो भी है, केसेस शुड बी हर्ड बाय हिम until and unless वो बॉर्डर पे जा रहा है। बॉर्डर का मतलब पाकिस्तान ही नहीं, तब पंजाब का बॉर्डर। एंड वन मोर थिंग, इसमें ऐसे लिखना, और मैं ऑर्डर कर रहा हूँ, लो, when this case was taken up, इसमें लिखो आप, by way of this petition, the petitioner has approached this court with the prayer that a direction be issued to the Financial Commissioner Appeal to hear the appeal filed by the, to hear the revision filed किया ना सर आप?
Yes, your lordship.
Filed by the petitioner against the order passed by the divisional commission. ठीक है सर? Impugned order कौन सा है?
Impugned order है लॉर्डशिप, लास्ट impugned order 24/2/2025, सॉरी लॉर्डशिप 16/10/24 का लॉर्डशिप।
Where is that?
That is annexure lordship, P2 lordship at page।
अपील की कॉपी वगैरह भी नहीं लगाई हुई है? अपील की कॉपी क्यों नहीं फाइल की हुई है? जो आपने एफसी के पास अपील फाइल की है, कहाँ है वो कॉपी?
Lordship, kindly pass over lordship, I will bring।
But why do you file half-baked petitions in the High Court? Was it not incumbent upon you to have had filed the copy of the grounds of revision या जो भी है, revision की कॉपी लगाई है आपने इसके साथ, जो एफसी के पास फाइल किया?
No lordship।
फिर why should the court believe you that any revision has been filed?
Lordship, I will append it this।
But why have you not appended it? मेरे को ये बताओ, डर था कि किसी और वकील के पास भाग जाएगा क्लाइंट?
No lordship।
फिर and where do you say so that you have filed a revision? क्या लिखा आपने? To hear the revision against the order passed by the divisional commissioner, which revision petition has not been taken up for consideration. It has not been listed for consideration since it's being filed in the month of February 2020.
Yes, your lordship।
Learned counsel for the petitioner has apprised the court that the case was first listed on
21st of March lordship।
21st of March 2025, but the court did not assemble and the case was ordered to be listed for today.
Yes, your lordship।
That is the 30th of May 2025.
Yes.
He further submits that as per the instructions of the client who had gone to the office of the learned financial commissioner in the morning, again a date has been given for कब की सर?
20 June lordship। 20 June।
20th of June 2025.
Yes, sir।
On the direction of the court, learned additional advocate general was asked to have instructions in this regard, and he apprises on instructions that the court of the learned financial commissioner shall be assembling today at 2 p.m. Be that as it may, this case will be taken up in the post-lunch session. In the meanwhile, learned additional provide the data to the court that as from 1st of January 2024 till 30th of May 2025, on how many dates the court of learned financial commissioner appeal was ordered to be assembled, and on how many dates actually the financial commissioner appeal has heard the matter. ये मेरे को डाटा दो 1 बजे तक, साइन करा लेना। सारे के सारे चाहिए मेरे को। किस दिन लगा था, जैसे आज हुआ ना कि 4 दिन बाद रख दिया। कंप्लीट डिटेल, तारीखें कौन कौन सी लगाई हुई? यस प्लीज। जीवेश।
Lordship, the petitioner is a permanent resident of the Lordship. As mentioned,
issue क्या है?
Issue is Lordship, the petitioner has a house, Lordship, at his village, Lordship, and he has applied for the domestic water connection, Lordship. And the respondent, Lordship, has not till date, Lordship, has taken any steps to provide the water connection.
Who has to do the need?
This has to be done by the Lordship. The respondent number, Lordship, 3, Lordship. Rampur Lordship, because he is a resident of, he has several representation has been given Lordship. Even the Lordship in the year 2022 Lordship, the water pipe has been laid Lordship, but the water, necessary water collection has been not given Lordship.
But what is the reason? ऐसा तो नहीं होगा, it is not.
Kindly see next fee 10. वो under consideration, कोई order नहीं है।
आपको पता होगा, बताना नहीं चाहते हो अलग चीज।
नहीं कोई नहीं है। I have annexed all the document Lordship. Kindly annex P10 Lordship, page 28. Then Lordship.
Notice AG साहब accept notice list on dash response in the middle. 4 प्राइवेट लोगों के साथ तो नहीं झगड़ा वगैरह। Dhananjay, yes Dhananjay.
Malad, I may kindly permit to withdraw the present petition, Lordship, with the liberty to file with better particulars, Lordship.
Learned counsel for the petitioner submits that as there is a technical defect in the petitioners be allowed to withdraw the same with liberty to file a fresh petition on the same cause. Petition is allowed to be withdrawn with liberty as well.
Might transfer Mr. Vedant.
Yes, Nirdesh. Yes.
Yesterday was a holiday. I spoke with the concerned official. I am paying the only part business.
है क्या केस क्या है?
Contempt petition to pass the consideration order on the
पेंशन पे क्यों लगाई?
Lordship, the son of the petitioner is suffering with cancer, Lordship, and
ओके पास हो।
he required.
इसमें कितना क्या है डायरेक्शन क्या है? पैसे नहीं मिलने इनको कुछ एरियस वगैरह है?
नहीं ट्रांसफर का है जी। मदर इज
अच्छा वो कोर्ट से जो आता कि
हाँ जी
राजेश कुमार यस प्लीज।
Well, this is a contempt of an interim order, my lord. And the main
क्या था?
order, my lord, may see, main petition is listed now for 5th, my lord. My lord, the order was C1 at page 7, my lord. Needless to say, during the pendency of the petition, selection, appointment on regular or officiating basis, if any, to the post of vice chancellor shall be made strictly in terms of the Act, my lord. But my lord, what they did during the pendency of this, I put a separate challenge to that order also, my lord. They, because the Act says extension can be granted for a period of 1 year, but since the main this thing was challenged, they gave him officiating charge, which was to be given to the senior most professor. So even that could not have been given, my lord. So that is the contempt. I have made an amendment in the main petition also. That is also listed for 5th. If my lord will list it on 5th along with that.
Who are the respondents?
Here the this contemptor would be this secretary on
Petition दिखाओ।
petition, my lord. Petition, yes, he is a party. He is a party. They appeared also. This order was passed in their presence.
That is not the issue.
Please, lord. This is the petition, my lord.
Where is the order of extension?
Yeah, this order of this. This is because I prayed. Yes.
You see, there is one problem.
Please,
The order is that selection appointment on regular or official basis.
please.
It is neither selection nor appointment. What the governor has done is.
Officiating.
Sorry, you see, please read. What the governor has done is to continue in his office. This is no contempt. This is no contempt.
My lord, my submission is if my lord can see the scheme of the act.
I am not interested. Contempt may, if you argue the very fact, if If the learned counsel has to explain or make submissions to demonstrate that there is a contempt, then law is that there is no contempt. Because contempt exercise should be cleared out from the contempt.
Yes, this is what I'm saying, that
So I'm dismissing it.
my lord may appreciate one fact, my lord. Because the court, the honorable court which passed the order, and this was passed on this thing only, that an officiating charge has to be given. The officiating charge has to be given to the senior most professor.
So I'm passing the order. Because sir, by way of this.
My lord, my submission is, if because on 5th this matter is listed.
No, I'm not. You see, I have the power to pass an order.
No, I don't say that my lord do not have the power to this.
There is no.
My lords have the power.
There is no contempt, Mr. Bhushan.
No, my lords may see, this is a sheer.
So I'll pass the order. Likho, sir,
no, if my lords may at least hear me before passing. My lords may have it too, क्योंकि मेरी ऊपर चलेगी, मैंने पढ़ना तो उसमें से.
But what kind of a contempt petition is this, in which the petitioner does not even append the order purportedly on the basis of which the order passed by the High Court is flouted?
Please, madam.
What kind of a contempt petition is this, in which the petitioner does not even append that order, passing of which purportedly amounts to flouting of the order passed by the High Court?
If that is so, then at this stage I withdraw it. I will place I place that on record. Because in such circumstances it gives license to the people to flout the orders, because they know. एक और भी है जी वो भी नहीं एक और मेरी प्लीडिंग का वजह, मेरी एप्लीकेशन भी एक ऊपर चलेगी ना जी उस फाइल में.
नहीं मैं समझा नहीं, ये तो मैंने कंटेम्प्ट की रखी थी.
नहीं कंटेम्प्ट के लिए एक तो मैंने पिटीशन दी थी ना जी, एक मैंने वो दिया जो मैंने रिट के, हाँ ये वाला.
Yes, please. Vaibhav Tanwar. What is the order?
Order is lordship that higher state may be
Notice 4 weeks. This or that.
Please, Lordship. My contempt petition, Lordship. They were directed to consider my case, Lordship. Only the consideration order.
2 weeks.
Grateful, Lordship.
Rules of liberty.
In this contempt petition, Lordship, they were direction to release my dearness allowance, Lordship. And Lordship.
Just give me notice.
Grateful, Lordship.
Sir, इसमें ऐसा ना, you see,
Please, Lordship.
when the order has been passed by the court, that if it is not paid within this time, that it will entail interest. Contempt नहीं बनती, file an execution. You have to file an execution.
I'll file.
Withdraw it and file an execution.
Yes, I'll file.
Learned counsel for the petitioner is permitted to withdraw the petition, but simply to file an execution.
Grateful, Lordship.
उसके साथ आप execution.
So, Lordship, the conditional order was there, Lordship. If they were not paid within stipulated period, Lordship, then 5% interest.
अभी क्या हो
Please, Lordship.
Execution file करो.
Grateful, Lordship.
Yes. Rajinder, खिड़की खोल. Yes, please. Yes, Thakur sir.
My lord, this writ is pertaining to the acquisition of land by the sale deed, by way of sale deed by the NH.
Yeah.
In fact, Your Lordship.
The similar matter was listed yesterday and notice has been issued, my lord. Ji.
Notice.
And it may be clubbed together,
The
my
Union
lord.
of India is not a necessary party in this matter.
Okay, notice confined to respondents 2 and 3.
Ji.
Confined to respondents 2 and 3 at this stage. Reply within 6 weeks this thereafter.
These are all similar matters up to D10, Your Lordship.
D10, my lord.
Notice.
in other matter for Union of India.
Notice नहीं कर रहा हूँ मैं यूनियन ऑफ इंडिया. वरना लगा दो इनकी हाजिरी आप लोग.
लगा दीजिए.
के लिए. सब में ही.
जी.
Lordship in D6, Mr. Virwan.
किस पे?
In D6.
आप बता दो जिसमें लगती है ना, काइंडली टेल वो लगा दो.
D10.
यूनियन ऑफ इंडिया.
Lordship, it is taught by Annexure P9, Lordship. In this petitioner is seeking direction for acquisition, Lordship, and similar matter has already been.
Notice 8 weeks. Ashwini Kondar.
Please, why way of this petition, madam? The present petition praying for the allotment of the additional land, madam.
बताइए please.
Please, madam. Madam, the mother of the present petitioner, my lord, is the owner of the EWS plot, my lord, situated at Unna, my lord, building number 177, my lord. The land adjoining to her plot, my lord, is in the shape of Nala, my lord, which was developed by.
How can the High Court pass such orders?
My lord, in the similar cases, my lord, the plot additional land has been issued, my lord. Kindly have an extra P5, my lord, at page 3.
By the direction of the High Court?
No, my lord. The respondent has allotted this. Please, last paragraph. That the available land shown can be allotted to the allottee of house number
A
177.
mandamus be passed. मेरे को आप ये explain करिए ना. How can a mandamus be passed?
Because, my lord, in the similar case, my lord, they have given.
I don't know. Maybe that that act may not be in consonance with law. How does Himuda allot plots or land? These are public largesses, not stricto sensu public largesses.
Please, sir.
But Himuda is a statutory authority.
Please, sir.
ठीक है ना? इनकी जो allot, it is by way of process.
Please, sir. I'm not.
Maybe I'm interested in that Nala.
तो जी नोटिफिकेशन कर दें जी अगर
तेरे को दे देना है. Petition में कुछ नहीं.
Otherwise, we have developed the land, to the similar situated person, they have allotted.
I don't know if someone challenges.
Kindly have an extra for a movement,
Someone challenges it, court may have a different take altogether.
Because I have approached all the authorities,
Where is the legal right vested in you to have that land allotted to you? And because that legal right of yours is being frustrated by the Himuda, therefore you come to the High Court seeking.
I am ready to pay the amount,
Mr. Please appreciate what is coming from you. I'm
allowed is right, man.
You, which legal right of yours is being fringed by the omission on the part of Himuda to allot that plot to you? Iska answer do.
Only, since this land is in the shape of Nala, I have developed this land by investing a huge amount, After that, otherwise there is no plot, After that, they have carved out the plot,
आपने नाले पे क्या करना है मेरे को बताओ.
कुछ नहीं जो किचन गार्डन के लिए मांग रहे जी हम किचन गार्डन के लिए मांग रहे और
करो एक दो कौन सा देख रहे
रिप्रेजेंटेशन ट्रीट करवा दें.
सॉरी एक ट्रिब्यूनल थोड़ी है.
रिप्रेजेंटेशन है जी मेरी 2023 की पड़ी है जी पेंडिंग
6 महीने बाद डीम टू हैव बीन रिजेक्टेड.
इसका कर दें.
सुप्रीम कोर्ट का लॉ है. एनी रिप्रेजेंटेशन 6 months is deemed to have been rejected.
I humble submission because
humbly dismiss कर दो. Court का sir, this is not the job of the court. Legal right बताओ, infringement बताओ, I'll intervene.
Because the other landholder has been given, that has been given.
Two wrongs will not make a right. I'm not saying that what has been done is right or wrong. This is not analogy. उसको दे दिया तो मेरे को भी दे. Because by way of this petition, the petitioner is praying for the following reasons. The case of the that EWS किसको मिला हुआ था
ये जी 174 वाला.
170 आपको
मेरा 177 है जी 174 को एडिशनल लैंड
आपको 177 मिला है ना.
हाँ जी.
आप जो ये कीमत मांगे को दे देंगे.
हाँ जी.
फिर आप पहले तो ये क्वेश्चन किया जाए कि आपको EWS में मिला कैसे होगा. If you belong to economically weaker section of the society, how today you are in a position to pay them whatever they demand?
पहले तो मदर को मिला था, मदर की डेथ के बाद
आप अमीर हो गए.
प्लीज सर.
By way of this, the case of the petitioner is that EWS, that one plot bearing number 177 was allotted to the mother of the petitioner. कहाँ पे सर?
Unna में. Rakkad colony.
In the Rakkad colony developed by Himuda at Una district. According to the petitioner, there is a vacant land adjacent to the said plot, and the petitioner has made a representation to the authorities for allotting the same, for the allotment of the said additional land to the petitioner on 11th of August 2003. As the petitioner intends to do some kitchen gardening on the said land, however, till date no action is being taken thereupon by the petitioner. It is further averred in the writ petition that earlier proceedings were initiated against the petitioner for having encroached upon the land by Himuda by constructing a shed. In fact, मैं आपको बताऊं sir, this is nothing but abuse of the process of law. 50,000 cost डाल रहा हूं मैं इसको dismissal के साथ. It is a very simple case. There is a vacant land of Himuda
Vacant, please.
adjacent to your plot. आपने उसके ऊपर नाजायज कब्जा किया. इन्होंने वो नाजायज कब्जा आपको हटाने को कहा. God knows whether it has been removed or not.
Remove कर दे सब कुछ.
अब आप कह रहे हैं कि अब वो मेरे को अलॉट कर दो.
मैंने तो रिक्वेस्ट ही की है जी.
लिख लेना. पहले लास्ट लाइन पहले लिखा देते हैं. According to the petition is dismissed with cost rupees 50,000.
My cost में
तो चुपचाप withdraw it. Don't.
I'll withdraw.
After making the submission of some time, learned counsel for the petitioner prays is permitted to withdraw the petition dismissed as well. After making the submission of some time and finding that the court was not with the petitioner, learned counsel for the petitioner prays is permitted to withdraw the petition dismissed as well. हाजिर लगा बाकी कुछ नहीं हुआ. पेड़ काटने चाहिए इन्होंने मेरे 2-3 पेज लगने. Yes, please. Yes, Pradesh.
Your Lordship, this is against the award of the learned labour court, Your Lordship.
आपके खिलाफ किया कि partly?
It is partly allowed, Your Lordship.
Yes. मैम आप लेंगे HVSC बिल पर 22 की अपनी कैपेसिटी में. 22 किसके?
Virender Kamar, Your Lordship.
वरिंदर. आपका नाम?
मोहिनी कांता.
वरिंदर कंवर मोहिनी कांता. ठीक है. For respond. Reply in 6 weeks this thereafter. So meanwhile we just need to requisition the record from the brother.
Please.
Yes, please.
There is one application of mine, my lord, under 17B, my lord. But my lord, before that, my lord, I'll just refer to one order, 171019. May have it, my lord.
Just one. ये 17-20 की भी 2020 से पेंडिंग है.
Yes, और उससे पहले जो ऑर्डर देखेंगे 17-10-19 का जी, my lord, passed by the honorable court, my lord. Yes, my lord. There will be an interim stay subject to reinstatement of the respondent within 2 weeks, my lord. My lord, thereafter what I did was I have attached those letters, join my lord, letters, my lord, intimating them that I be allowed to join, my lord. They have my 17B application, my lord.
They are not allowing me to join.
My lord, they have not allowed me to join. Neither, my lord, they have, my lord, when I moved an application for 17B, my lord, reply was filed by them. They say, my lord, that I'm doing some.
To the application still not filed.
Filed, my lord. Filed है जी, इन्होंने फाइल किया हुआ जी. मान लो इनका है, ये बोलते हैं जी कि ये जी कोई टायर रिपेयर की दुकान चला रहा है. मान लो अंडर 17B, मान लो इट्स ओनली इफ आई एम वर्किंग इन एन इंडस्ट्रियल एस्टेब्लिशमेंट. मान लो टायर की पंचर की दुकान चला रहा है.
But question is if you are on your livelihood somewhere.
Yes, my lord.
Issue तो livelihood का ना.
नहीं जी, उसमें है जी I should not be gainful. मान लो मैं 17B for a minute. मान लो it says not gainfully employed in an industrial establishment.
You see.
I bring the law to that effect also. I bring that law to that effect. मान लो
इसका मतलब है कि अगर उसने कोई एक बड़ा सा शोरूम.
नहीं बड़ा मान लो they did not, they have just averred it, my lord. No documentary proof attached, my lord.
File a rejoinder.
I'll file a rejoinder. But my lord, till then they should be made उस high court या stay vacate कर.
When the High Court had granted the interim subject to the condition that you will re-engage him, why have you not re-engaged him? 17B or no 17B? As from the date 2 weeks after 17th October 2019, you are bound to pay to that person the money if he has shown his willingness to join the service. Not only you will seek the instructions, you will also have instructions that who was the person at the helm of the affairs at the relevant time, so that whatever is payable now to the respondent from that date till date, it will be recovered personally from that erring officer. ऐसे लिखना. When this case was taken up for consideration today, Mr. Mahajan, learned counsel appearing for the respondent, has drawn the attention of the court to the order that was passed by the Honorable Division Bench on 17th of October 2019, in terms whereof the interim grant to the petitioner's state was subject to the reinstatement of the respondent within 2 weeks, and has submitted that thereafter, despite the petitioner giving his willingness to join the duty, till date the petitioner has not been re-engaged by the respondents. Learned Additional Advocate General is directed to have specific instructions in this regard as to why the order passed by the court, by the Honorable Division Bench of this court, has not been implemented till date. The court will also intimate as to who was the officer at the helm of the affairs when the order was passed by the Honorable Division Bench. Because this court is of the considered view that if the petitioner is found remiss in the obedience of the directions passed by the Honorable Division Bench, then it will be the erring officer who shall be responsible to personally compensate the respondent for the entire period, and this compensation shall not go from the coffers of the government. List on dash 3 हफ्ते के बाद.
I also filed the reply, man. It's been.
In the meanwhile, rejoined to the.
Star दी man.
तो आप खुद stay लिया हुआ है और उसके बाद.
And my lord, I have attached 2 registered letters, my lord. My lord, after passing of the award, another after passing of the order by the honorable court.
Problem is that until and unless जिसको कहते हैं ना personal responsibility fix जब तक नहीं होती ना तब तक कुछ नहीं होने वाला. And I have ordered in some cases judicial orders have also been passed to this effect that fixed responsibility. No one is willing to do that. Mohan Sharma.
Right.
Yes, please. So last date of hearing, the respondents were directed to seek instruction with respect to the.
Okay. मेरे को दो मिनट में फैक्ट्स देना मुझे. When was he initially appointed?
He was initially appointed, Lordship. He was initially appointed on Lordship 12th of December 1977, Lordship.
Okay.
And subsequently, he was promoted as a senior assistant on 1/1/1986.
Just one. Senior assistant on
1/1/1986.
Okay.
And he, Lordship, moved an application for retirement on medical ground on 20th February 2021. Medical ground on 2001.
दो की चिट्ठी का है.
It will be in the court.
Lecture A15. आपके पास है ये A15? प्रिंट की कॉपी होनी फाइल है आपके पास?
फाइल है पुरानी फाइल.
A15 दिखाओ जरा एक मिनट प्लीज. Show me A15.
It is
A15 10/7/2002 की चिट्ठी है.
Page 40.
Just show me.
Please go. Page 40.
Certified that. नहीं ये नहीं है. Where is the order in terms whereof he was retired earlier?
We have also annexed at page 11 of the reply.
Of the reply.
In the reply.
Writ में कि इसमें?
इसमें execution. 11 नहीं है, इसमें नहीं है. No, this is a subsequent reply. This is of Lordship. No, this is not. This is Lordship of 2011's order. Because earlier he was retired on the basis of voluntary retirement.
See, it's a very simple thing. It's a कई बार ना you see कहते हैं ना कि devil lies in the detail. It's a very simple thing if I've understood the facts correctly. This person was retired in the year 2000, 2002. You come to the court and say कि ये retirement मेरी गलत की हुई है. High Court accepts your case and says that he ought to have been retired from the year 2005. ठीक बात है ना? तो 2002 की जगह 2005 से हाईकोर्ट ने कहा आपको रिटायर माना जाएगा. अब जो इनकी सर्विस कैलकुलेट लेंथ ऑफ सर्विस कैलकुलेट होनी है फॉर द पर्पस ऑफ डिटर्मिनिंग द पेंशन, वो होगी अप टू 2005. पहले की थी 2002 तक, अब होगी अप टू 2005, मीनिंग देयर बाय कि 3 साल और जुड़ेंगे. ठीक है ना? आप 3 साल घटा कैसे रहे हैं? ये है सारे का सारा केस. इट इज नॉट कि पहले इनको 5 से में रिटायर किया और कोर्ट ने बोला कि नो ये 2 से रिटायर हो गया. उल्टा है, आपने कर दिया 2 से, कोर्ट ने कहा 5 से करो. किस चीज की क्लैरिफिकेशन? किस चीज? तो कोई इंक्वायरी तो आई हुई है, क्लैरिफिकेशन उनसे करा लो. इट्स अ सिंपल केस. देयर इज अ डेट ऑफ ज्वाइनिंग, देयर इज अ डेट ऑफ रिटायरमेंट. दैट डेट ऑफ रिटायरमेंट हैज बीन एनहांस्ड बाय 3 years बाय द हाई कोर्ट. तो जितना पीरियड है उसके पीरियड के बेस के ऊपर पेंशन देनी है. इसमें कौन से पहाड़े पड़ने हैं? What kind of clarification is required? I fail to understand. Until and unless there is something which neither the court has understood nor Mr. Mohan has been able to put forth to the court. सर किस चीज के कमेंट्स? मेरे को आप ये बताओ ना, लॉजिक बताइए. Please go through the order that was passed by this court.
And you see page 29 में.
Page 60 पे, accordingly in view of the observations made herein above, petition is allowed. Annexure A4 dated so and so is quashed and set aside. Petitioner shall be deemed to have prematurely retired on medical ground with effect from 30th of May 2005 with all consequential benefits including the benefit of so and so. Period between 25/7/2002 to 31/5/2005 shall be treated on duty for all intents and purposes. This is the direction part. अब फिर मेरे को ये बताइए ना कि क्या है. हाँ, अगर प्रीमेच्योर रिटायरमेंट ऑन मेडिकल ग्राउंड के बेसिस पे पीरियड की कर्टेलमेंट हो रही है या है, वो आप स्पेल आउट नहीं कर रहे हैं इसमें कि ऑन व्हाट बेसिस. आपका अगर सप्लीमेंट्री, अगर आपका एफिडेविट देखा जाएगा ना सर, तो प्लीज गो थ्रू द एफिडेविट फाइल्ड बाय यू.
Kindly see internal page 7 of my affidavit. My grudges with respect to the.
Okay, please come to para 5 of the reply. That the contents of this para are incorrect. It is submitted that petitioner was voluntarily retired on 31/5/2005 and accordingly his pension case was forwarded to the office of AG with class of pension being voluntary in compliance to the direction of tribunal, wherein weightage of 3 years and 3 months was added to the qualifying service under 48A. With qualifying service of 30 years 5 months so and so. It is further submitted that thereafter his pension was revised in view of the directions passed by HP Government Finance with merger of so and so. Accordingly, the pension was fixed. It is pertinent to mention that thereafter the petitioner filed another writ petition, which was disposed of by the High Court in the following terms. Further, the government directed the office to implement the judgment. The revised pension was prepared and sent to the office of so and so, wherein the weightage of additional qualifying service was withdrawn, resulting thereby total qualifying service was reduced to 27 years 5 months with effect from 1/6/2005. It is pertinent to mention here that all this has been authorized on the basis of the prayer of the petitioner. It is also incorrect to avert that salary has not been paid. ये आपका स्टैंड है. तो आप एक्सप्लेन करिए ना कि पहले आप कहते हैं कि इसको किया वॉलंटरी रिटायर, फिर हाई कोर्ट के ऑर्डर के बेसिस पे ये हुआ प्रीमेच्योर रिटायर. तो अगर स्टैंड आपका ये रहा है कि बिकॉज वॉलंटरी रिटायरमेंट से इसको 3 साल का बेनिफिट मिल रहा था, जो प्रीमेच्योर रिटायरमेंट में कन्वर्ट होने पे हमारे को विड्रॉ करना पड़ा, इसलिए हमने नंबर ऑफ ईयर्स जो रिड्यूस किए हुए हैं. आप उसका प्रोविजन दिखा दीजिए कहाँ है. अगर है तो है, देन यू हैव नो केस. आप यू गेट द पॉइंट ना. ये है सारी, इस पे असिस्ट करो कोर्ट को. अगर तो ये इनकी बात में ठीक है, देन यू विल नॉट गेट एनीथिंग.
That is yours.
इसमें ऐसे लिखना आपने. Having heard learned counsel for the part, the only issue which now requires consideration in this execution petition is as to on what basis the weightage of additional qualifying service of 3 years, 3 months, which was earlier allotted to the petitioner, was withdrawn by the respondent, purportedly in compliance to the judgment passed by the court in a writ petition filed by the petitioner, that is CWPT number 5926 of 2008. A learned additional advocate general prays that he may be granted 2 weeks time to file affidavit of the authority concerned, concentrating on this particular issue only. Let needful be done in 2 weeks as prayed for, list on dash. अगर आप वो justify कर देते हैं ना सर, कोर्ट क्वेश्चन नहीं करेगा उसको, but please justify it. Black and white में, otherwise logic नहीं लगता मेरे को, that's all. Devinder.
In this case, I have to take the steps for bringing on record the legal representative of the petitioner, Lordship. I have called them, Lordship, but he could not get the legal air certificate.
बंदे आ रहे हैं?
हाँ, वो तो है.
Okay, learned counsel for the petitioner prays that the legal representatives of the deceased petitioner are in the process of filing an appropriate application to implead them as petitioners. Therefore, the case be taken up after 4 weeks order according.
Wait.
और दो फाइल तीसरी अपॉर्चुनिटी होगी.
हाँ जी. वो बोल रहे थे कि तहसीलदार
लीगल लेयर नहीं है, जल्द जैसी एप्लीकेशन.
ठीक.
इस फाइल एंड एप्लीकेशन.
ठीक. मैं I'll
फाइल एंड एप्लीकेशन. Miss Deepmala. Yes, ma'am.
Lordship, we have received the total amount of rupees 22,63,000 something, and Lordship, the interest part has not been given to us.
Just 1 minute. Latest compliance affidavit है. Show me the judgment, ma'am.
Lordship, kindly have the page 13.
No, Mr. Jaswal, ये कह रहे interest part रह गया.
Lordship, according to the order, needful was to be done within 90 days.
90 days.
Balance amount is 1,72,000.
The additional advocate general prays for and is permitted to file the compliance affidavit in the registry. List on dash. 15 दिन के बाद लगा देना. In the meanwhile, response if any dare to be filed by the petitioner. Vikas Darki.
Please, my lord. My lord, India seeks time to file instructions, my lord.
The order क्या है?
Please, my lord. Order, my lord. They have directive to protect my pay.
नहीं, मेरे हिसाब से तो नहीं है, but madam is disagreeing with us.
Yes. इसमें order क्या है?
My lord. Order, my lord. Page 10, my lord. Accordingly, the writ petition is allowed to the extent that the petitioner are held entitled to the last pay drawn by them.
Petition of pay as well as benefits which shall be given to the petitioner from the date they submit. Okay. आपको जो पैसा अभी रहता है कुछ
1 and 4 का तो my lord they are giving instruction, but with respect to 2 and 3 they are saying nothing, my lord.
क्या है
वो elementary वालों ने करना जी by respondent number 3, my lord. ये डायरेक्टर हायर एजुकेशन
एक ही नहीं हो गया हुआ. Okay, learned इसमें लिखना in terms of the instructions imparted by the learned additional advocate general on the basis of the instructions received by him. ये ऐसे लिख दो काट. The learned additional advocate general on the strength of the instructions received from Director Higher Education dated 20th of May 2025 apprises the court that amount as was payable, as was admissible, have been paid to respondents 1 and 4. Learned counsel for the petitioner submits that nothing is being stated with regard to petitioners 2 and 3. Learned additional advocate general submits that he may be granted some more time to have instructions in this regard, as these instructions are to be obtained from Director Elementary Education. That date will be done by the next date of hearing. 3 हफ्ते के बाद कर देते हैं.
Please, my
petitioner to learned counsel for the petitioner may ascertain as to whether the areas as are payable to petitioner 1 and 4 have been received or not.
Please, ma'am.
Next. Yes, please, Mr. Udit Shivani Priya.
Please, Your Lordship.
Yes, Pradesh.
The reply stand filed, Your Lordship. And in reply, they consider my case and rejected, Your Lordship. So,
Liberty there.
liberty.
The counsel for the petitioner submit that now the appropriate authority has passed an order, though the same is against the petitioner. He prays that the proceedings be closed, but with liberty to the petitioner to assume the same in accordance with. Proceedings closed with liberty.
I appeal for responsibility, Lordship.
Yes, Mr. Bhushan. ये क्या है सर?
My lord, may have the judgment. My lord, judgment is at page. My lord, may just have the operative.
Absorb the services of the petitioner.
Please, my lord. Yes, but my lord may have the direction, para 13. In result, the instant petition are allowed. 19, my lord. Allowed, and the board is directed to absorb the petitioner in board initially on contract basis and thereby by way of revelation exactly in the same manner as has been done in case of bill-based employees. The entire process should be completed. This is 28 September 2023.
The order has attained finality.
Yes, an LPA filed, dismissed.
अब क्या कहते हैं सर?
And now they have filed a compliance affidavit. They absorbed my services on contract basis in January 2025.
आपके हिसाब से कब होनी थी सर?
After completion of 8 years, as the bill-based employees were given in 2020.
आप एक काम करो. You just file a rejoinder thereto within a week, or yeah, response thereto within a week or so. That will be better. Bring in these facts on.
Please.
Irigna compliance affidavit stands filed. Learn senior counsel prays that a week's time be granted to counter the same. List on dash. Let deedful be done in the meeting. उन्हीं भी को लगा दो. छोटा सा matter.
This is a commercial arbitration. The commercial arbitration, malas, they have filed the objections under section 34. The pleadings are complete, malas.
Case अभी इसकी stage क्या है case की?
But they have filed the rejoinder also.
Pleadings are complete.
Please, my lords, pleadings are complete, your lordships.
Learned additional advocate general submits that as arguments in the case are to be addressed by the learned advocate general, the case be taken ordered accordingly. ठीक है? Yes, please, Ravinder Singh. Mr. Chandet साहब ये क्या है सर?
ये execution थी जी वैसे और last date मतलब they have supplied instructions not. But earlier not these instructions were never supplied to me.
Just one. नितिन आपका क्या स्टैंड है?
It stands compliant. We rejected it. In fact, on the last date of hearing also we said that we communicated it to the petitioner as well on 16th of August 2019.
They seem not in the year 2019 not. Whereas not after the passing of the judgment not, this matter in fact was taken by this not executive council also not. How could they take it thereafter not? Had it been complied not, it could not have been taken not.
These are my instructions.
Matter
इसमें I'll direct them to produce the minutes of this meeting. क्योंकि minutes को तो rewrite नहीं कर सकते हैं.
जी बिल्कुल.
अगर minutes में ये है तो then फिर तो आप इसको challenge करते रहो और वो ये कैसे? ज़्यादा नहीं help कर सकता. Court cannot go into the issue.
I have the judgment which was passed. If you also kindly have. In so far as prayer 1 and 2 are concerned, the learned counsel of the on instruction that the applicant does not want to press at this stage, and it was only for the 3.
What he is saying is, कि according to as per his instructions, कि जब तक ये case file नहीं किया हुआ था, इन्होंने ये matter take up ही नहीं किया हुआ था. What he said. As per your instructions और जो आपने memorandum दिया है, ये matter place हुआ था in its meeting held on 13/6/19, ठीक है? नंबर 25. अब अगर वाइड आइटम नंबर 25 है, तो आप इतनी आइटम में तो मैनिपुलेट करोगे नहीं.
जी.
ठीक है? तो show me that those minutes है ना? ठीक है? That will इसमें लिखना In order to put an end to the controversy as to whether the case of the petitioner was considered by the Finance Committee on 13th of June 2019 or not, Learned Counsel for the University is directed to produce the minutes of the meeting of the Finance Committee of the University, dated 13/6/2019 in original, for the perusal of the court.
Much obliged.
अगले बुधवार को ले आओ.
Great.
Yes, sir.
Please, my lord. In this case, my lord, I have moved one CMP, my lord, for early hearing, my lord.
What is it?
My lord, sorry, my lord, senior counsel is assisting.
Subsidiary lordships. Their case has been rejected by a state itself.
By the state.
Yes, ma'am.
P38, page 124.
Just 1 minute.
Lord, see.
Hearing की कौन सी सत्यवादी? Minutes कौन सी? ये पूछ रही है. Okay, इसमें लिखना early hearing में. In the light of the above made in the application, the same is allowed, and the registrar is directed to list the case for final hearing in the month of September 2020.
Please, no, clear to note.
Yes, please, Ms. Kanta.
My lord, this is the matter.
Gautam, I think is here.
Yes, yes, my lord.
Okay. या आपने करना है चार जी की आगे करना है?
After vacation.
After vacation.
Please, my lord.
Mr. Sharma praised that as the senior counsel, Shri R.K. Gautam, because of a bereavement in the family, the case be taken up after 3 days. Ordered upon. Please, sir.
Please, my lord.
Shri Dilip Chand, 5 to 7, sir. Respondents 5 to 7 served, present none, proceed against ex parte. क्या है ये? Mr. Dilip Chand. नहीं कोई है तो है नहीं है नहीं बनने तो एक बार अभी रहने देना पास होगा आएगा तो ठीक है सर नहीं आएगा Mr. Man Singh.
Lordship, now the respondent has filed a reply, Lordship, to the
R2.
Yes, Lordship. But now the charge of respondent number 2 has been taken by the government.
That will not make any difference. What
Lordship.
He has filed this response in his official capacity.
Yes, Lordship.
तो आप अगर इसका rejoinder देना तो दे दो भी.
Lordship, 2 weeks time you can.
Reply by stands filed by R2, rejoinder by. फिर देख.
ठीक है, बोले Lordship.
In 4 weeks is here. हाँ जी sir. Arun Thakur, Zen Technologies.
Yes, my lord. Against the common award, my lord, 2 writ petitions have been filed, my lord. The one writ petition is on the behalf of workers, and the second one is on behalf of the company, my lord. Actually, my lord, the case of the petitioner, I am appearing for the workers, my lord. In my writ petition, my lord, I am claiming that, my lord, the compensation awarded in the case is very less, my lord, because the Honorable Labour Court has allowed my petition, my lord, but the compensation is only to the extent of 25,000 rupees. They are appearing, my lord.
आप अपेयर हो गए. यार इसको खत्म करो. This has been already been heard.
Yes, please. Very short point is involved, my lord. Please. Section 33, my lord, of Industrial Disputes Act, my lord. Whether the dismissal or discharge under Section 33 will include retrenchment or not, my lord. My case is this, my lord, that it is not a simplicity retrenchment, my lord. It is a punishment given to me, my lord. So, my lord, the Section 33 come into picture, my lord.
Substantiate it.
Please, my lord. I will substantiate from the record, my lord.
Judgment है दिखाओ.
No, I will bear provisions, my lord. Section 200 retrenchment may kindly be seen, my lord.
दो action. आप बैठो आराम.
Please, my lord.
बताओ. Yes.
My lord, Section 200, my lord, retrenchment, my lord. I will read some provisions, my lord. It means the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action, but does not include. So I'm stressing upon, my lord, this otherwise than as a punishment inflicted by way of disciplinary action, my lord. Because in this case, my lord, we were
Let us see let us see the complaint filed by.
Please, my lord. That is, my lord.
आपकी रिट देना जरा, इनकी भी रिट को, अनिल की.
3633, my lord.
वो भी दो है.
My complaint, my lord.
Yes.
Is at page 88, my lord.
Page 38. Huh?
Please, my lord. 88, my lord.
88?
88, my lord. Annexure P14 annexed with their writ petition, my lord. Please, my lord.
इनकी रिट साथ में लगी हुई है, अलग लगी है सर.
साथ ही है जी इसके.
आप अपनी फाइल दो, मंगाओ इसको. Let us first read section 33A, then we will appreciate the
section
complaint itself.
Please, my lord.
Let us read 33A.
Section 33, my lord. Conditions of service, etc., to remain unchanged under certain circumstances during pendency of proceedings. During the pendency of any conciliation proceedings before a conciliation officer or a board, or of any proceedings before an arbitrator or a labor court or tribunal or national tribunal in respect of an industrial dispute, no employer shall, in regard to any matter connected with the dispute, alter to the prejudice of the workmen concerned in such dispute the conditions of service applicable to them immediately before the commencement of such proceedings, or for any misconduct connected with the dispute, discharge or punish, whether by dismissal or otherwise, any workman concerned in such dispute, save with the express permission in writing of the authority before which the proceeding is pending. 2. During the pendency of any such proceeding in respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to a workman concerned in such dispute, or where there are no such standing orders, in accordance with the terms of the contract, whether express or implied, between him and the workman, alter in regard to any matter not connected with the dispute the conditions of service applicable to that workman immediately before the commencement of such proceedings, or B, that is important, my lord, for any misconduct not connected with the dispute, discharge or punish, whether by dismissal or otherwise, that workman, provided that no such workman shall be discharged or dismissed unless he has been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer.
Now let us read your complaint.
Please, my lord.
Yes, let us read. Yes.
Page, my lord, that is.
Students are workers.
Claim, my lord, that is 88, my lord, annexure P14, my lord. And the relevant is at page 1992, my lord, para 7, my lord. That the perusal of the retrenchment notice will show that the same is not retrenchment but the removal of the petitioners for not joining the transport station at Hyderabad. The said removal of the petitioners during the pendency of the proceedings before the labor inspector is against the provisions of section 33 of Industrial Dispute Act and is liable to be set aside. Moreover, the said removal is without any holding any inquiry and is without giving any show cause notice to the petitioners, my lord. So my case is this, my lord. I was transferred, my lord. I didn't join the transport station, my lord. After that, my lord, they issued the retrenchment notice during the pendency of the conciliation proceedings, my lord. The wording of this retrenchment notice may kindly be seen, my lord. Page, my lord. Page 66, my lord. Annexure P9, my lord. Notice of retrenchment, my lord, that is of 29th of August 2017, my lord. You are aware that there is no work at our Nalagarh unit since few months. However, in order to protect your employment and to use your services effectively, the management had transferred you to our Hyderabad unit via our letter dated 8th of August 2017 and asked you to report on 21st of August 2017 at our Hyderabad unit. However, you have failed to report to duty at Hyderabad unit, and as such, it shall be construed as you are absenting to your duties. Accordingly, the management would be legitimately could initiate action for your absence from duty as per the model standing orders applicable to our plant at Hyderabad. Please. So, my lord, my contention is this, my lord, that
Please read section 33 once again.
during the pendency of any conciliation proceedings before a conciliation officer or a board or of any proceeding before an arbitrator.
What are the words used therein? Discharged or dismissed?
Please, my lord.
Now come to section 2A.
Please.
2 capital A. Where any employee discharges, dismisses, retrenches, meaning thereby that as far as these three words are concerned,
Please.
they are different from each other.
Please, my lord.
Now here, rightly or wrongly, they use the word retrenched.
Please.
Once they use the word retrenched, 33 is not attracted.
That is my case, my lord, because they have used the word.
They will not see it under. Labor Court does not has any jurisdiction to lift the veil and see.
Under
33A.
This petition is under Article 226 of.
No, sorry. This is a case where you are before the court for judicial review of an order passed by the tribunal.
Actually, my lord, it is the petition.
हाँ, तो मैं वही कह रहा हूँ.
So
the court prima facie is concurring with them. The court prima facie is concurring with them that this petition under 33A was not maintainable.
Actually, my lord, my case is the wording may kindly be seen of section 33, my lord.
Sir, there only two words are used.
Please,
if they are smart enough to use a word which does not find mention in 33, so be it.
Or any misconduct, my lord, not connected with the dispute, discharge, or word is used, my lord. After or there is punish. Okay? After dispute, after discharge,
you see,
my lord, there is a punish, my lord.
This is not attracted.
Yes.
They have not punished. They have drafted this very cleverly.
Yes, my lord.
They are not punishing you per se. They are simply saying that we have transferred you from station A to station B. You have not joined pursuant to the transfer order. Where you still are, we don't have any work. So we are retrenching you.
Taking action against
so much, Mister, don't put words in my mouth. There is no action. This is not this can't be an action.
In the document it has been mentioned, my
we had this is आपको 2A में जाना चाहिए. Nothing prevented you from. Please read section 2A. वहां जाकर आप बोल सकते थे कि ये इन्होंने जो किया गलत है. Please read 2A.
Yes, appropriate comments, my lord.
Where an employer discharges, dismisses, retrenches, or otherwise terminates, the workman can directly go to the labor court. You should have gone to the labor court under 2A. ये जो retrenchment है ये गलत है, चाहे जो मर्जी आप reason देते, that is not for the court to draft the petition. But unfortunately, 33 में, rightly or wrongly, termination retrenchment is not envisaged. So they succeed. The order goes.
My case is this, my lord, that this is a punishment by way of disciplinary action, my lord. Is excluded section 200, my lord. Yes, my lord. Please, my lord.
These statutory tribunals,
please, my lord,
they cannot travel beyond the power conferred upon them by the statute itself. Their powers are not akin to the High Court or even the quasi-judicial authorities. They are tribunals. They are tribunals.
Actually, my lord, they have to take the permission of the authorities.
I know that.
Please, my lord.
I know that. But before dismissing or discharging, not retrenching.
But my case is this, my lord, that this is a punishment by way of action, my lord. So section 33 will come into play, my lord, because of this, my lord. Because they have taken action. Because
you are 100% right.
Please, my lord.
But the road you chose to ventilate your grievance was not the path that ought to have been treaded by you. You should have gone to the labor court under some other provision. वहां पे आप ये सब क्लेम कर सकते थे 2A में कि हरासमेंट से इन्होंने किया हुआ, तंग करने के लिए किया हुआ, 33 को इवेड करने के लिए किया हुआ, लेकिन 33 में आप नहीं कर सकते.
These are my submissions, my lord.
ये नहीं पड़ेगी बात. आपकी कितनी पिटीशंस हैं?
इनकी
एक है, तो इनकी अलाउड आपके डिसमिस. ठीक है, आपकी अलाउ कर रहा हूँ, इनकी डिसमिस.
प्लीज
अनु, आपका नहीं ये एज सीनियर एडवोकेट. चलिए, डोंट टेक टाइम अननेसेसरीली.
प्लीज.
Please, Your Lordship.
Just 1 minute. Just बैठ कर इसको ठीक करा. Yes, please.
Please, Your Lordship. Your Lordship, I had filed an election petition. Election for Panchayat Pradhan of village Sari. Your
Who are
Lordship.
you?
I was one of the contesting Pradhan.
You are the candidate who has lost.
Please, Your Lordship.
Who was elected?
Elected private respondent this Anu Rangta. Anu Rangta.
Huh?
Anu Rangta.
Anu Rangta.
Yes, Your Lordship. Respondent number 6, Your Lordship.
Office of
Pradhan. Pradhan of Gram Panchayat Sari.
Show me the contempt. Show me the election petition.
Please, Your Lordship. Lord, may kindly have P1 page 16.
The order.
This is the order. Election petition, Your Lordship.
Then कोई बात नहीं. Challenge, grounds of challenge.
Yes, Your Lordship. Then, my Lord, may kindly have violation of procedure, Your Lordship, mainly. I have placed it, the petition on record along with my application for additional document at page 179, 181. Page 181.
What was the difference of votes?
Initially, it was 15 votes, Your Lordship. Then 2 more countings were done.
13.
ARO.
13. 13.
Only 13 votes were rejected. And yes, Your Lordship. P5 181 is the petition, Your Lordship. May I read it? That pursuant to the notification issued by the state of HP for conducting the election of Panchayati Raj institution in the state of HP, election for the post of Pradhan, Vice Pradhan, Jilla Parishad member, Block Development, Jilla Parishad Panchayat were declared to be held as per schedule. Date announced. The state of HP election were start on different dates 17/1/2021 to 21/1/2021 for different panchayats. The process has started with effect from 31st of December 2020 onward. The detail of process is given then, Your Lordship. The para 2, Your Lordship. That the tenure of previously existing elected representative of the different forum of Panchayati Raj institution was expired on 23rd 1/2021. And as per provision of the SAD Act, the state of HP was pleased to reschedule the process for the election of new panchayat, as the first meeting of the same was to be constituted and to be held by 1st of February 2021. Then 3, Your Lordship. The petitioner being one of the electoral of the above panchayat, along with above noted respondent, filed her nomination paper for the post of Pradhan, Gram Panchayat Sari, Block Development, Jubbal, Kotkai, District Shimla, HP. The election of the said panchayat was scheduled to be held on 21st of 1st 2021. It is also material to mention that respondent was declared to be elected Pradhan by returning officer, who was deputed to hold the election as demonstrated supra. The petitioner feeling aggrieved by the illegal declaration wherein the respondent number 1 has been declared elected as Pradhan of Gram Panchayat Sari, hence the present petition has been filed on the following grounds. That the entire election process for the post of Pradhan of Forsaid Panchayat is null and void, as no proper procedure provided by the law was followed. This is the main ground. The 13 votes which were cast in favor of the petitioner has been declared invalid by returning officer, despite the objection from the side of the petitioner. As such, said 13 votes are valid, as the intention of the voter in the present case was absolutely clear, and the said 13 votes were cast in favor of the petitioner. 3, Your Lordship.
The electoral has a fixed stamp, proper stamp in the said 13 votes, which were cast in favor of the petitioner, which was declared invalid by the returning officer. In the above 13 votes, intention of the elector was clear, which were cast in favor of the petitioner. Those 13 votes were not double stamped. It is pertinent to mention here that there were near about 7 double stamped votes, and said votes were declared valid by returning officer. Returning officer was bound to declare the said 7 votes invalid, but did not do so. In a number of cases, apex court has held that where intention of the elector is clear, the voter should not be treated as invalid. However, in case the identity of the voter should be disparaged by some visible representation, the returning officer was bound to declare the votes valid, which has been cast in a manner permitted by law. Moreover, the result of the above election has been materially affected by the improper reception of different votes, which were managed to be casted by the.
According to you, the findings returned by the appellate authority are bad.
Please, thus my contention is, my stand is that the ARO did not follow the procedure prescribed under the law, election rules.
Go through the
Please.
order that has been passed by the appellate authority.
Please.
The simple reasoning that has been given by the appellate authority is that your counting agent, a polling agent,
please.
He agreed to the voting, to the counting of the voting, and in the light of this fact, you were stopped from seeking recounting. This in nutshell is what has been held. Demonstrate that these findings are perverse.
Yes, Lord. The final counting. They say he signed.
Let us see the rules, that's it.
Please, Lord. Lord, may kindly have rule 79 first, Lord, of election rules.
They have been quoted in the order.
Yes, Lord. They have quoted it. May I read it?
Please do.
Rule 79. It says, after completion of the counting and preparation of result sheet, this is very relevant.
When did the election take place?
On 21st 2021, 21st January 2021. Same day the result was declared.
Let us hear this case in the month of March 26.
अब तो खत्म ही है जी, that is what I am saying. और इसको कर देते हैं जी आज जो. Please, Lord, I am reading 79 about it. After completion of the counting and preparation of result sheets.
Let us read 79-2.
Please, first, chalo, theek hai. After such announcement has been made, a candidate or in his absence, his election agent or any of his counting agent may apply in writing to the district election officer, panchayat, or returning officer, as the case may be, or any other officer authorized by him in his behalf, for a recount all or any of the ballot papers already counted, stating the grounds on which the demand as such. I understand also, but what is my contention is that without there being any application from any of the candidate or from the agent, the ARO on his own recounted the votes when the petitioner was being declared.
Contention is very simple. As per the first round of counting, he was the elected candidate. His argument is that this recounting was done by the officer concerned without any request from anyone. How do you justify that?
Please, Lordship. In fact, Lordship, I will fairly concede to this, that there was no application from either of the parties. But Lordship, my humble submission is, there was ruckus being created at the time of this proceedings happening. And it is only as per his submission that he was winning. It is his contention versus my contention. There is no basis for this. It is not led by any evidence.
It is said so in the orders. It is said so in the order.
In the order also, Lordship, that order is also without any evidence that they say he was winning. And to answer what what your Lordship said, this is true that there was no application from either of the parties. But my humble submission is, if the scheme of the act is seen, Lordship, his counting again is not perverse to the act. It is only something that he could have done on an application, and he has done it without an application. That much is there.
No, you see, it makes a hell of a difference. It makes a hell of a difference. You see, election laws have to be construed very, very strictly.
Please.
These are not benevolent laws, etc.,
That is true, Lord.
their construction has to be very, very rigid, very, very rigid. Now, in the absence of a right of seeking recounting provided in the statute or the rules, no one can see, no one can say that let a recounting be done. So it is a statutory right conferred. It is a statutory right conferred.
Now,
The
Lordship,
parties,
only question is,
the parties. A. Where is the power conferred upon the authority to recount the votes if there is no doubt raised by anyone vis-a-vis the first counting that, I'll not say first counting, the counting that takes place.
yes, Lordship, this distinction is very important, Lordship, because recounting as per the Act, there has to be an application. My humble submission is, recounting, one count can only be said to be happened when the form is filled and it is duly signed. Yes, he has counted, first he has made a count, he has not filled any form, he has not done the relevant important formalities, then he has gone again to count them. This much dereliction there is, I will fairly concede to this.
Oh, there is one more thing, just 1 minute. Mr. Yudhvir,
Yes, sir.
let us forget the act of the ARO for a minute.
Yes.
You will have to explain your conduct also.
Yes.
As per the findings returned by the learned Deputy Commissioner,
Yes.
he says, if you read page 46 of the paper,
Yes, sir.
therefore, respondent number 2 should have made an application before ARO for recounting and all the issues predicted. But since her agent had already accepted the result and put his signature, now it appears that what has happened is that this counting, recounting, etc., etc., it ultimately culminated into a final result. Your कौन है वो agent
Amit. But my humble submission,
उससे फिर then
if there is a procedural illegality, Your Lordship, merely by his signing, this cannot be operated as an estoppel, Your Lordship. But moreover, Your Lordship, even thereafter, my candidate, my Lord may kindly have, it is an admitted position, even by ARO has admitted
you see
that she has applied.
there is the provision in the act or the rule that after a particular stage the party can reapply.
For recounting, Your Lordship. Recounting this 79 is only there, Your Lordship.
79 the stage at which recounting could have been demanded. आपने डिमांड नहीं
नहीं हमने कर दी जी जब इन्होंने 3 बार करी नहीं मैं
आपने जब ये दस्तखत ऐसे करते हैं इसमें रिजल्ट मंगा इसमें रिकॉर्ड मंगा लेते हैं
हाँ जी मंगा लेते
Record was already summoned, Lordship, on last.
और दिखाओ जरा
हाँ जी मंगा लो देख लें जी बिकॉज इसने जब ये थर्ड इन्होंने करा जी व्हेन दे डिक्लेयर शी वाज नॉट इवन प्रेजेंट एट द टाइम व्हेन द ड्रॉ ऑफ लॉट्स वर
was not present.
माय कैंडिडेट लॉर्डशिप
Someone was present representing her.
नो even agent was not there इन्होंने कर दिया जी then she came with the application I am not satisfied with the counting.
How does the DC record the finding that जो फाइनल रिजल्ट है उसको आपके एजेंट ने साइन किया हुआ
अब पता नहीं जी कब किया होगा बट आई डोंट नो इट इज डन बाय प्रायर टू दैट नहीं जी पर उसको जी इट कैन नॉट बी ऑपरेट एज एस्टॉपल अगेंस्ट द कैंडिडेट लॉर्ड्स बिकॉज़ द
law is
clarity is there.
Law is very clear that there can't be an estoppel against an illegality.
Please
whether it will be an illegality. आप ऐसे करो मैं इसको पास ओवर करता हूँ दोनों बैठो रिकॉर्ड देखो
प्लीज
वो जो रेलेवेंट रिकॉर्ड है उसको फ्लैग करो
ठीक है
यस यस हाँ हाँ
Actually, also working in charge of secretary home and 3/4 Thursdays. And we had called the FC at 2 o'clock.
मैंने नहीं बुलाया
Sitting bench of this court. Then they have called the.
So ask him to hold the court.
I know that I have discussed the matter with the concerned advocate. He may go to the secretariat right now and they will pass the appropriate order. And the recording is.
There is some merit in what he was saying in the morning.
Actually, this FC got the charge 2-3 days back on the order. And now he is having.
But आपको मेरे को वो order आपको देना पड़ेगा.
We will provide order.
बोलो आप उनको no problem. I'll take it up at 2 p.m. Ask the council to go. उनको बोल दो आपकी जवाब. Yes, Abhinav Mehta.
Lordship, the petitioner did the BCom in the year 2009 to 12, my lord, from the Manavati University, my lord. And my lord, pursuant to that degree, he was, my lord. And that, and my lord, the इसमें जी ये था कि his degree
the degree on the basis of which, BCom degree on the basis of which he was appointed, that degree, there was that degree after verification was found to issued from the Manabharti University, and that was not verified by the.
It is of the judgment of the Honorable Division Bench. What can we do? There is that order passed by the Honorable Division Bench. So then a court on its own. आपके पास?
I know.
Where is that order?
Lordship, that order, but in fact, Lordship, in this the reply of the S number 5 has come.
There is an order passed by the Honorable Division Bench.
Lordship.
In court on its own motion. Where is that order?
Lordship, that order.
वो चाहिए because आप prayer कर रहे हैं ना, maybe that prayer is not maintainable before the High Court.
Lordship, then Lordship, I'll make capital Lordship. I'll go through that.
और ना सब ऐसे मत बोलो ना, जो मैं observe कर रहा हूँ. Kindly read the order.
Lordship.
तो देख के बताओ कि क्या वो आपको बार करता है, हो सकता ना करता हो.
Because Lordship, that order is not on record, Lordship, as of now.
करो ना, पता करो state को, उनको बोलो.
Lord, may then
lawyer representing Manav Bharti, lady lawyer representing करती. One lady lawyer represents.
Lordship, her name is
विनोद चौहान को, विनोद को पूछो या तो मैं इसको पास ओवर करता हूँ. Get hold of the order.
Lordship.
It has been passed by the division bench headed by Honorable Mr. Justice Talok Chauhan. Court on its own motion.
Lordship.
Yes, please.
Thank you.
Reply filed, rejoinder awaited. Rejoinder नहीं filed?
No.
Yes.
My lord, it may be fixed for the next week.
Pardon?
Next week, my lord.
Sir, आप rejoinder file कर दो, otherwise.
One more request. These are all 126 matter your lordship have kept in June. So all may be.
उसको एक ही दिन सुन लेते हैं.
हाँ जी, मैं I'll give the date और.
ठीक है. सर आप rejoinder file कर दो अगर करना है ना.
मैं
construed की जो board ने बोला है, then I not rebut what they have said.
All right.
List on dash as prayed for. Date में. Rejoinder if any in the meanwhile. हाँ, उसमें ऑर्डर देखना जरा.
Lord,
Yes, Mr.
We have filed rejoinder to the reply filed by them, but and there are no objections also. But
it is on record, sir.
It's on record.
It's on.
Yeah. Then
Case क्या sir?
yes, Lord. Actually, the government has constituted a committee headed by the chair, that wherever there is a damage to any structure or land beyond the ROW, right of way, it will be sent to that committee and committee will decide. What has happened in this case, that this was sent to a committee. Committee has given to these claimants or the respondents the amount which was actually to be the amount of for acquisition of the land lot, making no distinction between the price or the amount which is to be paid for acquisition and which is to be paid for damages. The land retains with them, Lord. It is with them, Lord. So that is because that is going to affect us in so many cases. And Lord will kindly see page 33. Only the relevant part I'll read. Lordship may have page 36, Lord. This is the committee's observation, para 1. The relief which is granted. The petitioner should be paid compensation for damage to their land, as per the rate adopted in award number so and so per square meter. So this actually partially his land was acquired. So what he's doing is that land is with him, but he's paying him what was paid by way of compensation.
Sharma, what do you say?
Malak, kindly have page 35. This number 4, Malak. The SDM Kala Solan apprised the committee that major portion of the land in question has slid down and could not be put to any use at present. beside these few trees standing on the land of the petitioner were also damaged. Because in fact, my entire land, I've also brought on this whole tree.
Speaking for myself, then the committee has to enter into this exercise and explicitly and expressly say that what portion has become unusable, उसके लिए हम क्या दे रहे हैं, कौन सा portion ऐसा है जो use हो सकता है, उसके लिए हम क्या दे रहे हैं. Because as the senior council submits, there will be a subtle distinction between the land that is acquired and the land that is damaged. Because मैं hypothetically बोल रहा हूँ, let us take a case that your land has been damaged. You are compensated to the tune of rupees 50 lakh. You may utilize that money so as to say in rejuvenating that particular piece of land and thereafter reutilizing it. Reclaiming it. Sorry, that will be the right word. Reclaiming it. As far as acquisition is concerned, the ownership goes.
Yes.
Ownership goes. Possession goes. Ownership goes.
Yes.
So that will be the subtle difference.
My submission is because the damage to what extent my land has been damaged, but it has been totally damaged and it cannot be put to any use in future. It is in between the road 4-lane and between the Kasoli road at Dharampur. That entire land has come down. That I have also brought on the record the photographs. And actually P6
अब पंडिता का ढाबा नहीं बन सकता नहीं है.
ढाबा
चल रहा है. ढाबा चल रहा है वहाँ पे.
कुछ नहीं बन सकता है.
Lordship में see page 44.
Because as per this notification, the committee has been given this right power to exercise. See whether
no one is doubting the authority of the committee. What is coming forth from the senior council and what is weighing with the court is that how can the compensation rate be equivalent to that of acquisition vis-a-vis damage? That is what
the committee has assessed the damages for the reason.
तभी तो ये आए हुए हैं. They are agreed.
For the reason because my land has been totally damaged. Totally damaged. It cannot be put in.
It says some portion.
It may take it away. We are not saying that we are not to.
Lordship में page 44 may be seen why it has happened. Page 44, second paragraph. It's not my report. It's the report again of the it is of the forest. Yes, last para. Further, RO reported that from the perusal of the spot site inspection, it is found that the entire land or area was damaged due to heavy landslide during the current rainy season in the month of so and so. At present, it is not possible to ascertain that how many trees, etc. Actually, there are trees are involved. Again, one can be compensated for trees. The land could be reclaimed, my lord, and it is because of the landslide. And the reason
that landslide you may have. NHI may be responsible for that landslide, meaning thereby that
I don't.
You have constructed the road that has loosened the strata, resulting in landslide. But question is that the report has to be elaborate. अगर वो rate देना भी है ना, then it has to be elaborately dealt with in the report itself.
Because it deals with solatium, everything is. It is 1 crore 3 lakhs for a small patch.
Section P9, it has been repaired or issued on 12th of January 2024. Though the damage has occurred much year to that, prior to that, because this is the third round of litigation. Prior to that, I filed a civil petition before this honorable court. By that, I was ordered to make a representation before the. I made a representation. They didn't decide. I filed a contempt petition. Again, contempt petition. Thereafter, they took a decision. Then they came forward before this honorable court with the report as which they are assailing money. Prior to that, I have written to them so many times. Legal notice was issued. They never. They were sleeping in deep slumber. They never came forward with the proposal that how much we are giving or not giving. Now, when this report has been prepared, now they are.
Unlike my nature, I've heard you patiently. Now, please answer the query of the court. How do you justify the grant of compensation on the same analogy on which acquisition has taken place? सिर्फ इतनी सी बात है, बाकी नहीं है कुछ.
Because now that is the report of expert committee.
No, there is no report.
That was up to there.
चलो मैं इसको set aside कर रहा हूँ. मैं इसको set aside
prior to that.
I'll relegate you back to the to calculate actual damages by applying certain parameters. Experts are वहाँ पे. They can be involved.
Because there is a conceptual difference between damages and the acquisition law. That I have detailed page 13, ground 2, my lord.
What is the response of the state? State का तो खैर कोई होगा नहीं. What is the response of deputy commissioner? Para? Please read.
It is specifically wrong and right that the
Para 12 कह रहे हैं आप?
it is specifically wrong and right that the definition of the damage as done by the score number 1 is justified and calculated, and the amount of the burden of public instruction as laid. It is humbly submitted that the meeting of the grievance committee under the chairmanship of score number 1 and the presence of all the members was held by Kerala with respect to damage caused to land belonging to score number 3 to 12. As per the situation of the superior engineer SPW forum and on the pressure of the SDL forum, the chairman of the committee held that the damages have been caused to the land of the score number 3 to 12 due to construction of the holdings. As such, it was incumbent upon the national highway or their agency to compensate the affected score number 3 to 12. Accordingly, the committee finally decided that the score number 3 to 12 should be paid compensation.
ये आप किसका रिप्लाई पढ़ रहे हैं? ये 3 to 12 का लग रहा है मेरे को.
इनका है जी रिकॉर्ड में, इनका रिप्लाई रिकॉर्ड में. That must be
just one.
12 का पढ़ रहे हैं.
Just give me 1 minute.
102 पे से शुरू होता है.
ठीक है, मैं
नंबर 1.
I've got it now.
104 से शुरू होता है.
If Advocate General, prima facie, जो ये compensation sir, if you come to para 2 of the reply filed by the deputy commissioner, है ना? He says, if you come to page 104, the committee has finally decided that respondent 3 to 12 should be paid compensation for damage caused to the land, measuring so and so as per the rate adopted in so and so minus solution. This appears to be slightly arbitrary. ये इसको you take time, क्योंकि ये और भी बहुत cases में आएगा issue. ये बहुत cases में आएगा. As to whether the damages can be equal to the rate of acquisition.
Of course, there can be my lord funding out, but apart from solution etc., because my land has been totally damaged.
So that you see, that is what is bothering me.
Yes, ma'am.
Ultimately, you remain owner in possession of that particular land.
Yes, ma'am.
You may recover it tomorrow, day after tomorrow. It can be reclaimed. I don't know.
We will, because if they are ready to take
after 5 years, 5 years when
we had even given a proposal. We had given a proposal for reclaiming the land.
After 5 years, when Mr. Anuprathar and I will be traveling, we may have lunch in Dhyanika Dhaba at that particular place.
बन ही सकता, ऊपर से गिरेगी सारी ढांक और ढाबा भी जाएगा. ये हाल है वहाँ पे.
Justify करना पड़ेगा. Let him
acquire is concerned, then acquire it. We will not.
No, we are not opposed to damages. Let them assess the damages.
The issue involved in this writ petition is as to whether the act of the committee constituted by the government to assess the damage caused to the land of persons like the private respondents whose land is out the is beyond
please.
Is beyond our right of way होता है क्या? Right of way. But is damaged on account of the construction of the NHAI. Was justified in granting damages at the rate on which the land has been acquired minus solatium and interest. Learned Advocate General submits that taking into consideration the issue involved in this petition, the case be taken up after 3 weeks so that he can assist you. Please condash us. Shooting about this.
These are two.
Pardon?
These are two written. Another one is Myanmar. That is connected.
Oh, correct. Please.
There is Sumit Raj. Yes. Yes, ma'am.
2 weeks time for filing joinder voucher.
Joinder, ma'am.
Please voucher.
Joinder not file, more time period for 2 weeks. 3 weeks.
Highly guilty. Lordship.
Yes, ma'am.
Through the record. Lordship, we have gone through the record now.
इसमें
No, Lordship.
just 1 minute. अभी देखिए.
Good afternoon, Lordship. This is, my Lord, on last date of hearing, my Lord. My Lord passed an interim order directing the respondent to, what is this? I do have. Just let me,
Okay, just yes.
my Lord, the interim order was passed by my Lord on April 28th, my Lord, directing the respondent to consider my application and deal the same in terms of section 80 subsection 2 and 72 subsection 1 of the Motor Vehicles Act within a period of 3 weeks. And the direction was also, while considering the application filed by the petitioner, the authority shall also take into consideration the judgment passed in coordinate bench of this court in CWP 6578 of 2024 titled as so and so, dated so and so, in journal, and para 6 to 9 thereof in particular. So, my Lord, before I start, I take liberty to read a judgment, my Lord. It is read by Honorable Supreme Court in case of Tirupati Balaji Developers Private Limited and others, State of Bihar and others, AIR 2004 SC 2351. I am reading, my Lord.
You see, let's do one thing.
Yes, my Lord.
Because this order has been passed by the authorities pursuant to a direction passed by the court, I'll direct them to place the same on record.
No, my Lord, this already they have placed on record.
They have not placed it on record.
So, my Lord,
just listen, please.
My Lord,
I'll direct them to place it on record by way of a simple application. You may file your response to the order. Then we'll see the legality there.
My Lord, I have prepared a copy for my Lord.
I am not interested. Otherwise, I will relegate you to the tribunal.
No, my Lord, I prefer to stay.
Then follow what is coming from the court.
Well, very well, my Lord.
Let आप इसको record पे लाओ. You file your response there too. Then we'll go.
Very well, my Lord.
इसमें से लिखना learned Deputy Advocate General has apprised the court on the instructions received from Director Transport that the STA ने किया ना सर ये that the State Transport Authority has passed an order on the requests of the petitioner and has rejected the same on the ground that the वो मैं वही लिख रहा हूँ सर ground that stage carriage permits cannot be granted without advertisement, है ना? Without advertisement ही है ना सर? Without advertisement per se. Be that as it may, learned Additional Advocate General may place this order on record by way of a formal application. Response, if any, to the order.
Very well.
Book objections thereto within 4 weeks. This
my Lord, 1 week is sufficient. My Lord.
मेरा mood नहीं है.
My Lord.
Make it date. We'll hear you on that day.
This controversy is settled time and again so that he cannot apply.
Only thing was I was reading on the last date. I don't know. I'm not making any observation. But there was a judgment of Honorable Mr. Justice Sandeep Sharma. जो पढ़ रहा था मैं. I don't know what will be the effect thereof. Huh?
There are judgment of the division bench of this honorable court in this case also. And
see, there is a in fact case filed by Mr. Ajay Sharma. This is exactly what he's saying. That you cannot allot any route without advertising this.
Yes, without advertising, in compliance of Maharash's direction, we a committee now identified the routes and advertising them. Yes, sir. So far, his claim is not advertise. Whatever I am applying, give it to me.
My way or highway.
My Lord, any
actual date will give.
Yes.
Shri Vivek Negi. Yes, Mr. Yes, Vivek.
Lordship, by way of this writ petition.
दूसरा केस कब रखा था सर?
My Lord, that is on 1st of July.
इसी को इसी दिन ले. Yes, Vivek.
Lordship, by way of this writ petition, we have assailed the notification whereby the rates of the village Bijan.
This is a statutory notification.
Please, Lordship. Please, Lordship.
Then it
Please.
will go the honorable division.
There is also one of the main rules of the state, though we have not filed a reply.
Pardon?
We have not filed a reply to point number 5 and 6. The state has filed the reply because notification of the state here.
Where is the notification?
Lordship may kindly have the page number 47, Your Lordship.
Page?
47 of the writ petition, Lordship. Sorry, I'm sorry.
Yes, statutory notification. इसमें लिखना by way of this writ petition, the petitioner has paid for the following duties. Taking into consideration the fact that the vices of a statutory stands aside by way of this writ petition, the registry will place the matter before the appropriate bench in terms of the roster in book. ठीक है?
In my Lordship file reply.
The matters in which the vices of statutory notification stand aside are to be listed before the honorable division bench. Yes, Shri KD Krishnan. Respondent, sir.
No, Lord, I am for the respondent. But both of them are filing a memo of appearance. One of my kindly grant me 4 weeks time to file my form.
Respondent served, it shall put in appearance. Wakalat Nama as well as reply within 4 weeks, list or dash. Reply गया. कितने मैटर है सर? केस कितने हैं?
Your Lordship, I am paying for a judgment. Your Lordship, can you take the matter next week, Your Lordship?
Reply not filed, no? Reply not. आपने भी नहीं किया फाइल? लिखिए.
Because our reply is not required because Your Lordship.
किया कि नहीं किया?
If required, I'll file, Your Lordship.
Okay. Reply not filed. 4 weeks more time is paid for granted. List I'll DB में जा रहा हूँ. I'll just come.
Lordship, may I take my lord's absent back to both?
Then we'll take up that case. उसमें देखा आपने? Yes, please. FC. Delete details वो FC वाले.
We are paying it days later.
हाँ, okay, no problem. ठीक है. What has happened to the?
Actually, problem ये है कि वहाँ कौंसिल कोई और है, यहाँ पे कौंसिल कोई और है।
हाँ.
अब वो वहाँ का कौंसिल कह रहा है कि मेरे पास फ्लाइट आई थी 3 दिन पहले, जो हमारी इन्फॉर्मेशन।
हाँ हाँ.
तो अब कोई उनका आपस में dispute, कोई केस अनलीगल डिस्प्यूट है।
Okay, let them come.
हाँ।
अगर if what they tell the court is incorrect, then I'll take them to task.
हाँ, मतलब यहाँ पे किसी और ने फाइल की।
That I understand. Mr. Satprakash. इसमें किया वो ग्रांटीनेड वाला जो है।
For 4-5 days तक।
कर रहे हैं ये?
हाँ, वो तो यही रहे।
बोल नहीं रहे हैं।
I don't know, keep it on next Friday. We will do it.
Learned Additional Advocate General submits that the respondents are in the process of implementing the judgment. And the case will take up after 10 days. From 23 को compliance affidavit in the middle. Yes, please. Yes, please.
Lordship, Madam has given me a copy of an order which is dated 25/4/2025.
Along with that, your lordships,
Don't worry.
overhauling has also been supplied to us.
Just 1 minute.
Lordships, what I've been conveyed is
Just give me half a minute. I'll come back. इसमें भी ना there is one problem. ये भी गलत है. तो इसको करके ना then I'll direct you to do it as per law.
afresh, your lordships. वो क्यों that will be
लिखा था किसी ने? आप कितना लिखा?
is clearly violation was
Violation.
just that is governed by softwares.
इसमें पता क्या है? इसमें कुछ नहीं है. आपने एक प्रोविजनल बनाना, इनको देना है. Objections लो, hearing दो और hearing दो.
Much applied.
But follow the process.
Please. Take care.
हाँ पहुंचे. Without providing any provisional assessment to the, he further submitted that in the absence of provisional assessment having been provided to the petitioner, the petitioner could not file any objections, which right vests in the petitioner as per the statute itself. Full stop. He further submits that no, Miss Sunita, ये जो है ना, ये भी does not suffice the purpose. So it's better कि आप procedure follow करके whatever action you want to take, है ना? ये देखा आपने?
मैंने देखा, एक मिनट.
हाँ. Take a
Fact remains that they have suppressed this fact from this honorable court.
This will not matter. ये आपका this act is as good or as bad as.
No, your lordship. When they file the petition, at least your lordship.
Do not.
Lordship, I may say with all humility at my command that I have sought instructions from my client that this communication of 25th of April 2025 has till date not even been served upon me. And there is a procedure of service
Your
under
lordship may
section
have-
171.
When this order was passed.
25/4 को.
25/4
पहले वाला.
11/4 को.
11/4. What they were doing till this, your lordship.
कल तक.
27. Your lordship, they should also come to this honorable court with their clean hands.
इससे कुछ नहीं होना.
And
Our act remains a bad act for all intents and purposes. Rather than summoning the petitioner, respondents will be well advised to summon the officers concerned. How to deal with their statutory powers in a proper manner.
yes, your lordship.
करो इसमें. मैं fresh order लिखा देता हूँ. I'll take care of this also.
Please.
Notice taking into consideration the controversy involved in this petition with the consent of the parties, the petition is being disposed of at this stage. By way of this petition, the petitioner has assailed provisional assessment notice dated 11/4/2025, annexure P1, which reads as under. Learned senior counsel appearing for the petitioner has invited the attention of the court to the provisions of section 126 of the Electricity Act 2003, full stop. He submitted that in terms of section 126 of the Act, comma, the assessment officer, wherever he makes provisional assessment, comma, has to serve such provisional assessment upon the party concerned. Thereafter, objections are to be invited on the provisional assessment, and after giving the party an opportunity of being heard, final assessment has to be made. He submits that there is no provision in section 126 of demanding the deposition of provisional assessment as has been ordered within annexure P. Full stop. He further submits that the petitioner has not been given any provisional assessment along with the provisional assessment notice, and therefore the act of the respondents is bad in law. Now, senior counsel appearing for the respondent university handed over a copy of final assessment notice to the court dated 25th of April 2025, in terms whereof the respondents were directed to deposit amount of rupees 13,67,978 as finally assessed.
Yes, finally, sir.
And she has submitted that the petitioner has concealed this fact from the court, that final assessment notice was also served upon the petitioner. Be that as it may.
One more thing, if your lordship, para 2 may also be quoted that they were given opportunity through representation for
No, sorry. You see, I'm not sitting here to this. You are not appreciating what I'm telling you from the morning.
I am appreciating.
Please tell me one thing. आप किसी को when a memo is issued to an employee, memo is issued, उसमें लिखा होता है file your response within 15 days. To what? To the article of charges. Article of charges, so-called provisional assessment कहाँ है? He is not supposed to. The petitioner is not supposed to advert to these 4 lines. He is supposed to revert to a provisional assessment order.
Your lordship.
Where is that assessment order?
Your lordship is correct, but your lordship may have that they were given opportunity to file representation.
To against what? Against what?
Against this amount. If
how this amount has been determined?
They could have gone there.
Sorry, that is the statutory responsibility of the board.
Now your lordship may appreciate one thing. There is a now meters which already they are also aware that this much load the software is.
Okay, let us do one thing. Let us close HP Electricity Board. ताले लगा देते हैं वहां पे और मीटरों के बेस पे जो कंज्यूमर को पैसे देता रहे. Why these officers are sitting out over there who do not even know what are the provisions of the Electricity Act?
Yes, your lordship. That your lordship is correct. But your lordship, what prevents them?
Ma'am, you are arguing in a constitutional court. Please do not forget it.
Yes, your lordship.
These arguments are coming from a senior counsel.
But opportunity was given.
Opportunity against what?
वो वहां जा सकते थे.
Why should they go there?
ऐसे
Why should they go there? Why should they go there? It is the statutory responsibility of the board to act in a particular manner.
And your lordship, they have supplied this, how they have assessed it. So overhauling was also given. This may, one line may be added. My submission may be noted. Otherwise, your lordship order is right. We are not saying that your lordship.
I'm staying it, you file reply. Notice.
Only one submission, your lordship. That my contention is that though we have given the time to file representation, your lordship may not appreciate that.
Learned senior counsel further submitted that in terms of provisional assessment notice dated 11th of April 2025, opportunity was granted to the petitioner to file representation, which opportunity was not availed by the petitioner. Having heard learned senior counsel for the parties and having perused the provisional assessment notice, this court is of the considered view that the provisional assessment notice which has been given to, but इसमें ना एक चीज है, rightly or wrongly, today final assessment notice is also there. So
We'll have to challenge this.
you have to challenge it.
That is there. But this has not been served on me.
कौन सा?
ये जो final assessment.
Take it as service.
हाँ,
Take it as service.
I'll amend it.
File a petition by Monday will cost both of them.
हाँ जी, हाँ जी,
Will cost both of them.
ठीक है जी. Lordship, ठीक है जी, Monday को we will file it, Wednesday.
Will cost both of them. We'll pass the same order, but by costing both of them and give them.
Lordship, grant us, will freshly give them a notice. Why to? Only I have requested to.
No, I'll answer that. I'll answer that.
Yes, Your Lordship.
As well as the final assessment notice, which was handed over by the learned senior counsel for the petitioner. This court is of the conclusion that as there is a provision, that there is a statutory, that as there is apparently a flaw in the manner in which the respondent board has proceeded against the petitioner in this case, it would be in the interest of justice to quash the provisional assessment notice as well as the subsequent act of the respondent, but with liberty to the respondent to proceed against the petitioner in accordance with law.
Please, Your Lordship.
Section 120.
Please, Your Lordship.
As far as the contention raised by the learned senior counsel for the respondent that in terms of provisional assessment notice dated 11th of April 2025, an opportunity was given to the petitioner to make a representation is concerned, this court does not deems that to be an appropriate opportunity granted to the petitioner in terms of the provisions of section 126 of the Act for the reason that a representation could have been filed by the petitioner only against a provisional assessment order and not against a provisional assessment notice, which does not expressly speaks of as to how the demand that was mentioned therein stood arrived at by the electricity.
How they have calculated.
According to this court, along with the provisional assessment notice, they ought to have had appended the provisional assessment actually done by the authority, and it was and response any from the petitioner ought to have been sought with regard to the said provisional assessment order. Be that as it may, without making any further observation and without making any observation on the merit of the case, these proceedings are closed by setting aside provisional assessment notice dated 11/4/2025 as well as subsequent act of the respondent board pursuant to the issuance of this provisional assessment notice dated 11/4/2025, but with liberty to the respondent board to proceed against the petitioner afresh under section 126 of the Act with regard to the cause which resulted in the issuance of provisional assessment notice dated 11/4/2025 by following the statutory provisions contained in section 126 in that period.
Lordship, opportunity of hearing is necessary under one.
Yes, sir.
Highly grateful, Your Lordship.
Here, Ace court. Yes, Naresh. Yes, Mr. Naresh Babu.
Please. I have directed them to do the needful. I will be trying to keep it on Monday also.
है कि इसमें होना क्या है?
He is serving at government senior secondary school dean, Lordship, similar. And her husband posted that.
So will you pass the order by Monday?
Yes, Lordship, we are trying to accommodate. मैंने उनको वजीफा vacancy statement बोला नहीं पता करने.
Learned Additional Advocate General submits that the respondents are making an endeavor to suitably adjust the petitioner, and in order to enable the authorities to pass an appropriate orders, that the case be taken up after 2-3 days. List on Wednesday as prayed for. In the meanwhile, necessary order will pass. 5 दिन दे रहे हैं आपको, pass the order.
बोला जी मैंने.
बुलाओ जरा उनको. Yes, please. Rajesh, yes.
Also, the senior counsel is an honorable court banner at the moment.
Yes, please. 5 to 7 served, but occasional suggestion. As per the report of the registry respondents, 5 to 7 have been served, but none has put in appearance on the other. This case was called in the pre-lunch session as well as the post-lunch session. None has put in appearance on behalf of the petitioner. Dismissed. Next. Yes, please. Jyoti Thakur.
Lordship, I have flagged the relevant portion in the recorder.
How the? Where is your friend FC वाला case? Call him. तो बोलो जल्दी आओ. Yes. देना तो. क्या देख इसमें युद्ध भी है?
He has not signed the final result.
Not signed.
He has not signed it. Either the candidate nor the agent. It is there.
Look, there are two forms. One is form number 34 and other is form number 35.
Page 2 to 5 first may kindly be seen. This is a slip of draw. RW6 over B is the document. My lord may kindly read the content.
पर्ची निम्नलिखित एजेंट के सामने डाली गई.
हाँ जी, इसके एजेंट का नाम अमित है जी.
रज्जू का एजेंट.
हाँ जी.
आपके क्लाइंट कौन है?
मेरी रंजू है.
रंजू का एजेंट काउंटिंग हॉल से बाहर चले गए हैं और पर्ची ऊपर लिखे एजेंट के सामने डाली गई.
प्लीज.
आपके एजेंट कौन थे इसमें?
अमित कुमार था जी, मेरे नहीं किया साइन.
Lordship, now may kindly have to turn my lordship.
एक मिनट, अगला भी देखिए.
Why are you in hurry? Yes. अनु रांगटा एग्री फॉर्म.
हाँ जी.
अनु रांगटा जी है ड्रॉ के लिए एग्री है. अनु रांगटा कौन?
हर क्लाइंट. प्लीज.
और रंजू जी ड्रॉ के लिए एग्री नहीं है और वो हाल से बाहर चले गए.
प्लीज.
इसके बाद क्या हुआ?
इसके बाद देखें जी 230. दिस इज द फॉर्म 35 फाइनल रिजल्ट. D6 से जो ड्रॉ ऑफ लॉट से फिर दे ग्रांट हर एडिशनल वोट एंड डिक्लेयर हर इलेक्टेड. It is also not signed by neither my agent nor by the candidate.
One additional by?
इसको एक एडिशनल दिया ड्रॉ ऑफ लॉट से, टॉस करा शायद कुछ भी करा जी. One additional vote was counted in her favor.
जरा एक मिनट पंचायती राज वो देना इलेक्शन रूल्स. आपका क्या नाम है? रंजू. और ये नेक्स्ट पेज क्या है?
ये है जी 34. ये जब इन्होंने लास्ट ये काउंटिंग करी जी, दिस इज काउंटिंग शीट है लॉर्डशिप. दिस वाज साइंड बाय माय एजेंट. काउंटिंग शीट. Thereafter he objected. He did not participated in the draw process. This is under 34 section.
What is the procedure?
Yes, lordship. My lord, may kindly have.
Such a circumstance where there is a tie.
हाँ जी.
What is the procedure in the?
हाँ जी, है ड्रॉ का तो है जी.
Let us see.
एक मिनट देखिए.
79.
So
79.
first of all, let us agree on facts.
Please.
Is it correct that the respondent was declared elected by draw of lot?
हाँ जी.
It is a fact.
Asked. Yes.
There was a tie.
Yes, lord.
And then it was on the basis of draw of lot.
Please.
Okay.
In the end, yes, lord.
Now let us see the provision of the rules which govern such a situation.
Counting of votes first. Rule 73 है. Rule 73 है. Election rules 73.
Pardon, please.
Please. The returning officer or such other officer authorized by him in this behalf shall exclude from the place. Yes, sir. Other authorized by him this behalf.
नहीं है, ये नहीं है, ये इसमें कुछ नहीं है. ये किया हुआ section.
Say फिर 75 जी. Procedure for counting of votes. 75. The returning officer or any other officer authorized by him on the date, time, and place fixed under Rule 32 shall start the counting of votes in following manners. Now, namely, 1, the counting of votes. ATV. Equality of votes. हाँ जी. If after the counting of votes is completed and equality of votes is found to exist between the candidates and the addition, one vote will entitle any of these candidates to be declared elected. The returning officer shall forthwith decide between those candidates by lot and proceed as if candidate on whom the lot falls has received an additional vote. ये additional vote they counted.
This is Rule 80.
Please read.
Now you see, when there was a tie.
Please.
And the only option available with the RO was to follow this particular rule.
Please.
And if you leave the room, what option does he have?
But my humble submission is, Your Lordship, that the counting process, which 79 provides, Your Lordship, that was not followed.
How?
I say once she was leading, my client was leading. So it was income.
Here can it be inferred that she was?
Yes, Your Lordship. The statement, even presiding officer is saying.
So record.
Yes, Lord.
Producer.
My Lord, may kindly have first the statement of RW1. This is the Anu Rangta. No, I'm sorry. PW2, my lord. PW2 as page 65. Page 65. This is a statement of prosecution witness. Please, Lord. May I read it also? This is a cross examination. ये ऊपर से तो नहीं ज्यादा बीच में है जी, जहां पहले यह बताया गया कि पिटिशनर 15 वोट से आगे 15 वोट से विजयी घोषित हो गई है, फिर बाद पिटिशनर को काउंट हॉल में बुलाया गया और बाद में अनु रांगटा को विजयी घोषित कर दिया गया. फर्स्ट लॉर्डशिप, देन मैं काइंडली हैव पेज 91 lordship. This is RW3. Their response, their witness lordship. 93. This is Manoj Kumar, her witness lordship. And his cross examination starts from page 97 lordship. इसमें शुरू के थोड़ा 6 लाइन छोड़ के नीचे जी द्वारा करवाई गई पहले काउंटिंग में रंजू जीत रही थी और सेकंड काउंटिंग में अनु रांगटा. देन माय लॉर्ड में काइंडली हैव स्टेटमेंट ऑफ RW4 your lordship. He is the presiding officer your lordship. Page 97 में काइंडली.
Ma'am, in the peculiar facts involved in this particular writ petition, how do you justify the order passed by the appellate court? Who is to argue? आपने करना है?
I'm arguing.
Only one counsel will argue. बताओ, how do you justify the order?
Lordship may kindly have section 164 of the.
Forget the section. Let us proceed on facts first.
Please, Lordship. My only submission is, Lordship, in their petition.
Have you when these witnesses have said so, that yes, actually she was declared as winner, और उसके बाद हमने recounting की, आपने उसको क्या कहते हैं cross examine किया इस point पे कि ये गलत बोल रहे, झूठ बोल रहे, ऐसा कुछ नहीं हुआ.
नहीं, there is no.
So meaning thereby that this is a process which actually took place.
In fact, but Lordship, the statement that she has made.
So what is the harm that in order to maintain democracy and the democratic fabric of the country, what has been ordered by the authorized officer, let it be done. He has simply said.
I follow that, Lordship.
In fact, but he has simply said that let recounting be there, and if after recounting the votes are equal, there will be no fresh draw of lots.
Yes, yes.
ठीक है ना, क्योंकि draw of lots has gone in your favor, तो वो fresh नहीं होगा.
Please.
करवा लो recounting क्या जाता है?
May I submit, Lordship? In fact, the statement that my learned friend just read it. The witness says वो शुरुआत में जीत रही थी. That is a counting process wherein initially she might be having more votes.
आगे होगा वो candidate.
There is no conclusive fact. There is no conclusive evidence to this fact that in fact she had won in the first counting. They're merely saying this is. They were showing the kind of exit polls that who was winning first. And if I may point out section 164 of the Act, Lordship.
Let us read the statements of RWs.
Please, Lord.
Page 91 देखें जी एक मिनट के लिए. इनके RW के स्टेटमेंट पेज 91 है.
Page 91.
Please. It says in the middle lordship. जब काउंटिंग शुरू हुई, प्लीज. Is their witness, जोगिंदर सिंह.
हाँ पढ़ो.
प्लीज. जब काउंटिंग शुरू हुई तो प्रार्थनी के 249 मत तथा अंजू के 246 मत, अलबत्ता कुछ लिखा जाएगा. प्रार्थनी को पहली काउंटिंग के अनुसार 3 मतों की बढ़त थी. प्रार्थनी मतलब माई क्लाइंट लॉर्डशिप. अलबत्ता रिजल्ट घोषित ना किया गया, उसके बाद दोबारा काउंटिंग की गई.
ठीक है.
यस लॉर्ड. देन इन नेक्स्ट पेज लॉर्डशिप 92. यह ठीक है कि प्रार्थी को 259 वोट पड़े. Here he is also admitting, again admitting. Now my lord, may kindly see.
ये भी कहता है ये गलत है कि रणू को 259 पे वोट पड़े थे.
नहीं जी, ये कह रहा है कि प्रार्थी को यह ठीक है.
स्टेटमेंट
मिडल में जी, ये जोगिंदर सिंह इनका विटनेस है.
भूपेश कौन है?
He was one of the, Joginder Singh was one of the counting agent for one of the.
Who is Bhupesh?
Bhupesh was counting agent of one vice president.
The statements of the officers.
हाँ जी, ऑफिसर ये देखें, 97 में काइंडली भी सीन.
और वो कौन था?
ये RW6 था जी, पर एक मिनट के लिए प्रिजाइडिंग ऑफिसर का देखें जी, RW4, दिस इज पेज 97।
मनोज,
हाँ जी, हाँ जी, he was the presiding officer lordship,
just one minute.
प्लीज
पढ़ो प्लीज।
रीकाउंटिंग नीचे से लिख रहा है जी, काउंटिंग में, पहले काउंटिंग में 97 का मिडल में जैसे देखें जी, पहले काउंटिंग में अंजू जीत रही थी और सेकंड काउंटिंग में अनुराग था, एक वोट से जीत रही थी। इसके बाद लिखा है जी, सेकंड काउंटिंग में कुछ इस तरह लिखा, 2 वोट का फर्क आ रहा था, इसलिए हाँ जी, हाँ कुछ इस तरह लिखा है जी।
हाँ बोला,
बट इट इज क्लियर दैट इन फर्स्ट
को किया, आपको रिकॉर्ड किया गया था, ये गलत है कि 13 प्रार्थी को पड़े थे,
इत प्रार्थनी को 13 वोट पड़े थे।
एक तो
ये लिखा भी एक तो
सबसे बड़ा दिक्कत ये हो गया ना, अब ये जो सिस्टम चल पड़ा है ना कि एग्जामिनेशन इन चीफ जो है वो एफिडेविट पे होगी, दैट इज स्पॉइल्ड द एंटायर थिंग। अब वो रटे रटाए बयान आ जाते हैं।
अब 186 में जो ARO है जी, उनका एग्जामिनेशन है, क्रॉस एग्जामिनेशन, पेज 186 का।
वेयर इज द आरओ ने रिस्पांस फाइल किया था इलेक्शन पिटीशन को?
रिस्पांस दैट हैज टू बी सीन।
आरओ रिप्लाई बाय,
But he is admitting in his cross examination that
just 1 minute.
Please.
युजविंदर, प्रोबेबली देखो ये इलेक्शन जो है इसमें कोई 700-800 तो वोट होता है।
हाँ जी,
उन्होंने एक बार काउंटिंग की, उसके बाद फिर काउंटिंग की, उसके बाद फिर काउंटिंग की,
प्लीज
2-3 काउंटिंग करने के बाद दे कम टू अ डिसीजन that both the candidates have secured equal votes. That is something which fructifies in black and white. जो rules के हिसाब से final so-called step है towards the declaration of the result. Now, as per the rule, that was the stage where you ought to have objected and said that, sir, please recount the votes. आपने वो नहीं किया, तो
my lord, I have my lord, may kindly see,
because the act or the rules do not envisage कि काउंटिंग ऑफ वोटिंग जो है वो एक ही बार होगी और उसके बाद ऑर्डिनरली करते हैं 5 वोट है।
हाँ जी, बट रूल सेज अ लॉर्डशिप दैट जब फर्स्ट काउंटिंग होगी जी, काउंटिंग होगी, he has to prepare a,
there is no question of first counting, second counting. रूल्स राज कुछ नहीं एनविसेज करते। मैं आपको बता रहा हूँ प्रैक्टिकली हुआ क्या। प्रैक्टिकली हुआ ये कि इन्होंने एक बार वोट गिने, फिर इन्होंने दूसरी बार फिर वोट गिने, फिर तीसरी बार फिर वोट गिने। जब इनको तसल्ली होगी कि अब ठीक है, इन्होंने रिजल्ट डिक्लेयर कर दिया और उस टाइम जो है वो दोनों के साथ हो गए। उसके बाद आपके राइट एक्रू होते थे, आपने वो राइट्स जो है वो
नहीं जी, एक मिनट देखें जी, वो जी RW1 इनकी जो क्लाइंट है जी, उसकी स्टेटमेंट देखें, पेज 70 है लॉर्डशिप, पेज 70।
इन एक्सरसाइज ऑफ माय पावर ऑफ जुडिशियल रिव्यू मैंने कोई, आई एम नॉट सिटिंग हियर टू रीअप्रिशिएट द एविडेंस।
नहीं, पर ये था जी कि सो फार एज दैट वी अप्लाइड फॉर रिकाउंटिंग और नॉट, दैट इज देयर।
कहां पे
हैड,
कहां पे किया?
ये पेज 49 देखें, ARO की जी, ARO को
क्या कह रहे हैं?
एक मिनट, पेज 49 में काइंडली ये बोल रहे हैं कि इन्होंने करा।
कहां करा? Prove it.
मैं
वो जुबानी थोड़ा होता है. You have to apply in writing. कहाँ पे है वो?
हाँ जी एक मिनट जी.
Where is that on board? Have you alleged any malafides कि इन्होंने हमारी request फाड़ के फेंक दी?
Page 49 में kindly seen for a moment, Your Lordship. This is the letter written by ARO to SDM, Your Lordship.
कहाँ पे है वो?
59, Your Lordship. Page 59.
The writ petition.
हाँ जी.
Okay, बताओ सर.
Please, Lordship. इसका पैरा 4 पढ़ेंगे. I call both the candidates for draw. Both of them entered in counting hall, but Ranju denied to take part in draw.
पढ़ क्या रहे आप?
ये this is a letter written by ARO to SDM.
Age?
Same day. 59, sir. 23rd. Please. Ranju and her agent Amit move away in corridor with her husband Dinesh. I had taken in writing from them that they are not taking part in draw lots because her husband and candidate forcing me to consider rejected vote in her favor, for which they have given application. I had made note of that, and the vote was rejected before the totaling the vote of each candidate. So he is admitting that application was given in writing, which he rejected. This fact is also admitted by the respondent, Your Lordship. In her cross-examination, she is also admitting that she given letter, but because count was already completed 3 times, therefore there was no requirement for again counting, Your Lordship. Then RW3 also says, Your Lordship, at page 89, he also says that application was given, but it was not considered because already 3 times counting has been done.
Why does the RO record down in this particular complaint filed against her that she had applied, she had rather made an application that rejected votes be counted, and I have taken note of these things. अगर इन्होंने कोई ऐसी दी नहीं, you see, ये ना unfortunate problem ये है कि there are procedural lapses. Whether they are with a mala fide intent or bona fide, I can't comment. In the facts of the case, I think it is in the interest of justice that let there be recounting. Let there be recounting. और अगर recounting के बाद status quo है, then you are the winner. No one is going to say कि अब draw of lots फिर से होगा. Draw of lots जो हो गया वो हो गया. But let recounting be there.
Before that, my lord, kindly allow me to make a submission.
हाई कोर्ट से मैं यहीं से मैं I'll not dispose it off, मैं यहीं पे करवा देता हूँ कि recounting करके
ठीक है,
आपको बताया जाए कि क्या पोजीशन.
यही ऑर्डर भी
वो तो निचले ने किया ना. मैं I'm not SDM.
No, my lord. I just said that is also in my.
Let us do it. What do you say? Without prejudice to the respective contention of.
Please, Lord.
Just allow me to make a submission. Lordship, this petition that they had filed with the ARO, this goes to the root of the controversy, that this petition in itself, which is the genesis of this whole thing, it was not filed in accordance with the act. And as Lordships had already earlier pointed out, that the election laws, they have to be issued, and there is also a recent 2022 Supreme Court judgment on that. Section 164 of the act, Lordship says, may I read it? An election petition shall contain concise statement of the material facts on which the petitioner relies. B, shall set forth all particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged to have committed such practice, and the date and place of its commission of such practice, etc. And there is a proviso provided that where the petitioner alleges any corrupt practice, the petition shall also be accompanied by an affidavit in the prescribed form in the support of the allegation of such practice and the particulars thereof. Now, Lordship, they have tried in their first petition, they have alleged that some outside voters from different constituency came to participate in the election. They put bogus votes in the election, and they have made all such allegations. But neither there is an affidavit to that effect, neither there are names.
Contents of the election petition.
Please.
Well, we kindly have page 181. आपने पढ़ना?
In para, Lordship, may kindly see para 3 of the petition.
Just 1 minute. जरा पंचायती राज एक्ट दिया हो आपने मेरे को? Which section defines corrupt practices here?
164.
164.
Not defined exactly, but it says if you alleging corrupt practices, then you have to file affidavit.
Corrupt practices defined.
अच्छा हाँ वो देख
164.
Please.
they're relying on proviso to 160.
Just 1 minute. ये देखो corrupt practice means any practice specified in section 180. हवा में मत बोला करो. Corrupt practice is always defined. Corrupt practice, any gift, offer or promise by candidate or his agent or by any other person to stand or not to stand, including electoral. Where, according to you, corrupt practice has been alleged in the election?
Lordship. In para 3 of the petition, Lordship,
Oh, please.
a few lines down below, I'm reading from between. The returning officer was bound to declare the votes valid, which has been cast in a manner permitted by law. Moreover, the result of the above election has been materially affected by the improper reception of different votes, which were managed to be casted by the respondent number 1 in his favor, as most of the voters of the above panchayat were not present at the polling station. Rather, they were out of station, and the said votes of those persons was wrongly casted in favor of respondent number 1. And to name a few of them were not present at the polling station. However, respondent number 1 has managed to get their vote casted, and as such, these votes being invalid and illegal for the reason given below in favor of the respondent.
Okay, now read 180.
Hello.
Please, Lordship. The following shall be deemed to be corrupt practices for the purpose of this chapter. Bribery, that is to say, any gift, offer or promise by a candidate or his agent, or by any other person with the consent of a candidate or his agent of any gratification to any person, whomsoever, with the object directly or indirectly of inducing a person to stand or not to stand as withdraw from being a candidate or an election, b, a elector of the panchayat area to vote or refrain from voting to an election, or as a reward to 1, a person for having so stood or not so stood, or having withdrawn his candidature; 2, an elector of the panchayat area for having voted for refrain from voting, the receipt of agreement to receive any gratification, whether as motive or reward, by a person for standing or not standing as, or for withdrawing from being a candidate, or by any person whomsoever any other person for voting or refraining from voting, or inducing or attempting to induce an elector of the panchayat area.
I doubt as to whether this particular allegation falls within the definition of.
As per the section, that is true, Lordship.
Now, my lord, may kindly see. Petitioner was aware about the provisions. My lord, may kindly see page 184, Lordship. Para 7, bottom last. That though the election were held on 21 January 2021 for the above post, however, as per section 126 above the 1994 rules to 124 rules, the notification by concerned district collector cum district electoral officer Shimla was notified on 23rd January 2021, and as such, petition is being filed within statute limit. None of the grounds as prescribed under section 179 of the Act to be corrupt practice. Yes, admit.
Yes,
and it is verified duly.
Let the votes be counted. आप ballot paper यहाँ ले आओ. ठीक है ना? We'll have the votes counted by some independent person.
Please.
In your presence, आप दो में भी.
Please.
Recording करा देंगे.
Please.
क्या देख लेते हैं. That will be better.
That is the best for both parties.
But for some, but I'm saying अगर vote बराबर हुए.
तो अब 4 महीने बच गए जी.
Then he will.
May continue.
He will be बाजीगर. वाले को बाजीगर. Take away the cake. It has hurt for some time. Taking into consideration the controversy involved in this petition, court is of the considered view that it would be in the interest of justice in case the votes casted in the election are directed to be produced by the office of the Learned Advocate General before the court, so that recounting thereof can be ordered under the supervision of the court, which of course will be without prejudice to the respective contention of the parties. As there is no objection to the said observation made by the court, accordingly the case is ordered to be listed on dash, on which date the votes of the election in issue shall be next week, छुट्टियों के बाद produced before the court.
Please, grateful.
फिर देखते हैं. Facts confusing है, to be very honest. वरना मैंने decide कर देना था ये. लेकिन इसके facts ही confusing है. That is the unfortunate.
Lordship, otherwise also they have made their signatures as per form number 34, my lord, you kindly see.
Admittedly, but that is counting sheet. That I am admitting.
That is the final.
That is not the
paper,
final.
my lord, where they have signed.
The final is 35. That no one has signed. Grateful, Lord.
Original record of the election can be produced by the office of the Learned Advocate on the next record.
Please.
Next. Yes, please.
Please, Lordship. I have brought order, Lordship, that is CWPL 2020-22 of.
I have.
Please, Lordship.
I have it.
Please, Lordship.
इसमें ना आप ये देखो, what was the grievance of the petitioner before the court?
The grievance of the petitioner was he has come for verification of his
No, of the petitioners before the Honorable Division Bench.
Please, Lordship. Lordship, they have passed the degrees, Lordship. That is at Lordship from Manav Bharati University, year 2019, 20, and 21, Lordship. Got their provisional and the other passed out in the year 19, 20, 21, and have not got their provisional and other academic related documents because the university has been probed under the fake degree scam, and the matter is pending adjudication before the competent court. And so far as the petitioner is concerned, my lord, he is.
Now, please read para 11.
Please, Lordship.
The Honorable Division Bench has been pleased to make this observation. Then will a writ petition on the same and similar facts be maintainable?
No, Lordship. Then it will go as per this order, Lordship. Lordship.
आपको कहीं और जाना पड़ेगा जहाँ तक.
Lordship. And only with one thing I want to point out, because it has come that those students were of the year 19 to 2021. I am of 2009, and this is the court's knowledge, Lordship. I just pointing out that Lords may pass as the order as per this part.
क्योंकि दुख तो हमारे को भी है कि ये help कर नहीं पा रहे हैं, but in the light of the order of the Honorable Division Bench.
Lordship, please.
By way of this petition, the petitioner has paid for the following bill. The counsel for the petitioner as well as Learned Additional Advocate General and the counsel appearing for the parties. This court is of the considered view that as the Honorable Division Bench of this court in CWPIL number 22 of 2022 titled Court on its own motion versus State of HP and others, along which decided on 20/12/2024 along with other connected matters filed by students like the petitioner, has been pleased to hold that in the given facts, this court in its jurisdiction is not in a position to determine such disputed questions. Therefore, it is left open to the students to approach the competent court of jurisdiction for redressal of their grievance, The present petition is not maintainable, as in the light of the observations stroke order passed by Honorable the Division Bench, the petitioner will have to invoke the jurisdiction of the competent court for redressal of his grievance, as he is situated as but the other student petitioners who are before the Honorable Division Bench. Accordingly, these proceedings are closed without any observation on merit, but with liberty to the petitioner to approach the competent court of jurisdiction for redressal of his grievance. It is observed that in the event of any such process being initiated by the petitioner, comma, needful be done by the learned court concerned expeditiously as well as compassionate.
Watch my attendance.
This board
It's Mr.
presence.
Respondent 4.
Rohit. Yes, please. हाँ जी.
Lordship, the next date of hearing is the 20th of June, Lordship.
20 जून ही दी है अभी.
हाँ जी, Lordship. अगली please. Yes, sir.
Original counsel is application somebody else.
Yes.
Here the petition, first of the petition is different. Lordship. We are ready and willing.
ये क्यों नहीं आज आप बहस करने?
Lordship, जो FC साहब है, उन्होंने ओरिजिनल काउंसिल को ही सुना. Lordship, I was there, Lordship. वहीं गए थे. No, Lordship, original counsel was not there. I was there, Lordship.
आपको नहीं सुना?
उन्होंने कहा जी ओरिजिनल काउंसिल को सुनेंगे.
आपको क्यों नहीं सुनेंगे?
वो बोलते हैं वकालतनामा वगैरह.
तो इसका मतलब आपका एक ये बोल रहे हैं कि आपका अपना
या आज मैटर भी नहीं है. Also the matter was not listed today, Lord. Information.
Why did you make a false statement in the morning that the case was dismissed?
Lordship, as per the information received from the.
And I am dismissing this petition.
Lordship.
To impose cost on the petitioner for misleading the court.
Lordship, I apologize, Lordship.
No.
As per the 21 को थी Lordship.
I'll dismiss the case. I'll impose heavy cost upon the petitioner.
Lordship, I want to.
You cannot take the court for a ride.
Lordship, I want.
If the court can be strict to the state, it can be strict to the petitioner also.
Lordship, I went there as per the information received from the FC.
Case was not listed today at all.
Yes, Lordship. Not.
How did you make a false statement in the morning?
The information received from the client, Lordship. The next date.
1 lakh रुपया cost.
D square, Lordship.
1 lakh रुपया cost.
Lordship, kindly appreciate. Lordship. Lordship, may kindly appreciate.
Sorry, I will not allow anyone to play with the court. इसमें लिखना.
Lordship.
The case was taken up in the morning hours. The following order was passed.
Lordship, may I make a request, Lordship?
Learned Additional Advocate General submits that he has personally taken up the matter with the Learned Financial Commissioner who has apprised him that उन्होंने क्या what was the instructions? हाँ.
अब इनका
ये कह रहे हाँ.
काउंसिल कोई और है, इनका दोनों का आपस में हुआ.
क्या लिखा आपने? Financial Commissioner who intimated him that the matter will be taken up by him today itself. Let the learned counsel appearing for the petitioner appear before him. Now, when the matter was taken up again in the afternoon hours, learned counsel for the petitioner informs the court that the Financial Commissioner refused to hear on the pretext that he will hear only the original counsel. When confronted with the fact as to how, he further informed the court that the case is listed on 20th of June 2025 otherwise, and the matter was not listed today. When the learned counsel was confronted as to why a false statement was made in the morning, he said that the same was made on the basis of the instruction received from the petitioner.
Lordship, may I?
Court deprecates this kind of practice of making false and incorrect statements in the court just to gain the sympathy of the court and to create an atmosphere against the quasi-judicial authorities. Accordingly, before the matter is heard any further, for misleading the court, cost of ₹1 lakh is imposed upon the petitioner.
Lordship,
will be paid by the petitioner, which will be deposited by the petitioner with the register of this court within 2 weeks from today. Please don't dash.
Lordship, may I submit, Lordship?
Sorry.
Lordship, as per the information received from the client's Lordship.
संजीव करना है कि मंडे को करना?
Please, Lordship.
9 के 9 उड़ेंगे. 9 lakh रुपया.
Please, Lordship.
Sorry, I am extremely sorry. You say you misled the court in the morning.
Lordship, as per the.
वो सर क्लाइंट ही देगा ना पैसे. संजीव पीछे सीरियल आ रहा था, मैं तब डाल के बोला.
Lordship,
misled the court in the morning.
No, Lord.
You told the court that your client went to the financial commissioner. Financial commissioner के वहाँ से उसको डेट दे दी. When the AG takes up the matter.
Lordship, I highly apologize, Lordship. Lordship, नहीं तो मंडे को रख देते जी क्लाइंट.
गुंडे कुछ नहीं, 1 लाख रुपया जमा नहीं कराया ना.
I apologize.
उसकी प्रॉपर्टी की.
Lordship, उनकी प्रॉपर्टी जो है एविक्शन हो रही है, Lordship.
1 लाख रुपया कॉस्ट हर केस में.
Lordship, they are running the small focus, Lordship. During the pendency of the revision, Lordship may.
No interim as paid for. Interim rejected on the conduct on the ground of the conduct of the petition.
I highly.
को सुन लेते हैं.
मंगलवार कर लेते हैं.
मंगल को ले लेंगे. You just place that order on.
हाँ वो प्लीज कर दूंगा.
लिखना स्पर्श की लगाता हूँ.
थोड़ा कर दो.
Learned नहीं इसने नहीं. I'll take the petitioner. 1 लाख रुपया जमा कराओ.
Lordship में
He's a young man. Young.
नहीं Mr. Bhushan, you see.
मैं समझ रहा हूँ.
Court cannot be taken for granted.
नहीं बिल्कुल.
Not for granted. You can take the court for granted.
नहीं.
No.
Any time we people are here, you can take us for. No, I'm saying it in a healthy manner. That you can take the court. You cannot take the court for a right. You have to be doubly sure.
But Lordship, I have received the information.
Rightly, wrongly, I was also on that side for a fairly long time. So हम भी statement देने से पहले 10 बार सोचते थे.
मैंने उनसे कंफर्म किया था.
फिर उसको पढ़ा ना आपका.
Many times मैंने कंफर्म किया. मैं कहा जी श्योर है आप.
This operation Sindoor is not targeted against you. It's against your client, है ना?
Please, Your Lordship. उनके भी आप है. मैं ही apologize. Please, Your Lordship.
Nothing doing.
Please, Your Lordship.
They should know as to what is the cost of taking the court for a right. 9 लाख 1 लाख रुपए है collectively. 1 लाख रुपए सब मिलके जमा. मैं नहीं सुनूंगा इसको. मैं ऐसे लिखना स्पर्श का लिखना. हाजिर दोनों की लगाना. Mr. Sparsh Bhushan Learned is also submits that the case be taken up on Tuesday to enable him to place on record the order actually passed by the respondent.
Please.
Ordered accordingly. ठीक. ये नहीं. ये तो आपको उसको उनको मजा लगाना दिखाना पड़ेगा.
Lordship, उनके खोखे Lordship वो
खोखे हैं तो उड़ने दो खोखे.
During the pendency उनको प्रोटेक्ट किया जाए Lordship.
Problem पता क्या है?
Please, Lordship.
In the morning, I was extremely harsh to the learned advocate general.
Yes, Lordship.
ठीक है ना? I was also harsh to the financial commissioner.
Yes, Lordship.
And I was harsh for the reason जो आप कह रहे थे वो ordinarily हो रहा है. मैंने परसों एक केस में देखा. Yesterday I had called for the record. उसमें यही है कि 30 पेशियां हो रही हैं. 25 में जनाब है ही. बट ऐसा नहीं है. झूठ नहीं बोलना होता है.
Lordship, आज भी डेट सी पड़ी. मैं आज Lordship I was there Lordship.
जुडिशियल अथॉरिटीज है जी. एक केस में तो हमने रिटर्न आर्गुमेंट दे दिया.
तो भूषण I have passed a
20 साल पहले मैंने अभी ऑर्डर शीट ली.
I have passed
55 hearings and the presiding officer was absent. 50.
Passed a judicial order asking the state to review all its statutes कि जहाँ पे ये quasi judicial authority and with further observation कि if need so arises amend your acts. Let the judicial officers decide these cases. कम से कम decide तो होंगे ना सर.
कई जगह तो है. जैसे अब cooperative societies act में तो already there is a provision of this tribunal. This court took up also matter 1 or 2 times to create a tribunal because at least then those authorities would be judicial authorities. They will and there are thousands of the matters. So in one matter I am saying 2.5 years ago arguments were heard. Written arguments have been submitted. After on 55 occasions the presiding officer is absent.
In majority of the cases you can't blame the financial commissioner appeals also.
No, because they have so many others.
That depends upon how good his tahsildar is.
That is why that not old saying which happened that while filling the ACRs he said he writes very good judgments of tahsildar.
हम भी कोर्ट मास्टर को बोलते थे नहीं छूटा था कहाँ.
Lordship मंडे को रख दे.
एड्रेस
और पैसे जमा करो.
एड्रेस भी उनको
लिखा आप दिस. प्लीज Lordship.
1 लाख रुपया यकमुश्त 9 लाख नहीं कर रहा हूँ. ये क्या सर? पटेल.
This matter is also I am bringing 4 weeks to file the order.
Your Lordship, some short time.
क्या है क्या बताओ?
They have come against the Your Lordship. Though they have a remedy under 42(5) of the Electricity Act, but they have approached.
M says you have a statutory remedy. Why have you?
Principle of natural justice is involved.
So let us see. Show me the impugned order.
Yes, Your Lordship. It is annexure P2, Your Lordship.
Pardon, please. Sought recovery of wrong MF amounting to.
Yes, Your Lordship. It is stated that during the scrutiny of ledger account for the period so and so, a short assessment amount of rupees 25,96,961 has been pointed out due to the wrong billing of MF1 instead of MF2 for the period so and so till date so and so. Therefore, you are requested to deposit the same amount within 15 days from the issuance of this notice. Otherwise, This amount will be charged in your next monthly eligibility.
Shown in the next.
Don't.
Please, Your Lordship.
Interim is there, Your Lordship, and I have already deposited this conditional amount, Your Lordship.
Please read para 11 of your writ petition.
That furthermore, the current notice include areas of alleged.
Para 11. Para 12 के पता नहीं कैसे बनाते हैं आप ये petition, मेरे को समझ गया. Come to page 11. Read the 6th line from the bottom. That the petitioners are left with no other equally efficacious or alternative remedy. This is a false affidavit, according to the learned senior.
No, Your Lordship.
So then demonstrate that what she is saying is incorrect, that you have a remedy you have not.
I have, after vacation, Your Lordship, ordinary counsel will assist this court.
Huh? Original counsel यही तो था भी stay के लिए घूमा हुआ.
He has to go somewhere, Your Lordship.
करो 10 दिन के बाद. Rejoinder इसमें लिखना आपने. Just 1 minute. जब ये मैम इंटरिम हुआ था, कंडीशनल था ये, है?
Yes, Your Lordship. I have deposited the amount, Your Lordship.
जब deposited कहाँ पे?
So as per instruction, I have deposited on 7th February. 7th February.
Rejoinder not filed 2 weeks. List on dash.
Like it.
What date then? The contention of the learned senior counsel for the respondent board that the petitioner has approached this court without exhausting the statutory remedy shall be considered. Yes, please, Karan. Reply filed by R4 only.
Please, my lord. Reply is awaited, accepted, respondent number 4, my lord. I am seeking to sometimes for filing rejoinder.
Respondent number 2, I am.
आपने करना है फाइल? Okay, reply has been filed by respondent number 4. Other respondent number 2. The respondent number 1 and 2 may file replies to desire within 4 weeks. In the meanwhile, let rejoinder to the reply filed by R4 be filed by you.
Yes.
Yes, please. Dheeraj Thakur.
In this matter, Your Lordship, they had filed an IA. That has been not.
वही है, खुद रहो तो.
Please.
अब क्या लगी है वो?
That was listed for on 15th, and order was passed that it be tagged with on other applications which are listed on 21st. But on 21st, no order was passed.
थोड़ी दिन बाद 15-20 दिन. On the joint request list on dash.
Yes.
Same order.
Great.
Yes, Mr. Jaswal. Sole respondent represented by Vijay Kumar. आप आ रहे हैं?
2 weeks time for reply.
वकालतनामा दे दिए? Okay, वकालतनामा stands filed. Reply within 4 weeks this year. What's your good name?
Arun Kumar.
Arun Kumar, Vice Vijay Kumar. Yes, please.
My lord, we have received some instructions in that, my lord. But that deputy commissioner says that
Okay, just 1 minute. How many members are there to this total association? Just 1 minute. You see, in terms of these instructions imparted by the deputy commissioner, she has said that assistant registrar is expected to complete the investigation in 7 days. No, just wait. Let us just wait for 7 days. Let us just wait. I know that. I know that. How many members are there? 900. What is the impediment in the holding of the election? Just 1 minute. What is the impediment in the holding of the election, even if there is an allegation of financial irregularity committed by the present management? There is no law which says that if the present management is indulging in financial illegalities or irregularities, to election in you. Let us assume there is an allegation that X government is indulging in financial illegalities. तो फिर election नहीं होंगे state में. ये this is no answer. Inquiry आपने करानी है कराओ. आपने 7 दिन में मांगी हुई है ये. 7 दिन का मैं आपको टाइम दे रहा हूँ. But I want a clear-cut roadmap as to how and when the elections will be. ठीक है ना? ये नहीं है. This is no excuse because no law says. I fail to understand. On the contrary, if any only thing is, Mr. Sharma, if someone is indulging in financial irregularities or illegalities, then he or she, if found guilty, may be barred from contesting the election. But let us administrator, you appoint an administrator. You appoint. Problem क्या है? देखो ऐसा है, assuming that there is allegation of financial bungling is against the present incumbents, and as per him they are still in charge of the association. So you are so-called you are allowing the persons against whom allegations are to run the affairs of society. So you have no objection if administrator तो कर दे SDM को बना देते हैं एडमिनिस्ट्रेटिव. ठीक है, ऑर्डर पास कर दूं कि आप करो? इसमें लिख देते हैं, इसमें लिखूं. Having मंडे को ले लेते हैं. You convey the कि ऐसे ना the court has gone through the instructions received from the deputy commissioner cum additional registrar of societies Kullu, which are taken on record as prayed for the cases ought to be listed on Monday. Have instructions that let SDM be appointed. आप इंक्वायरी कंप्लीट करके एक रोड मैप दे दो इलेक्शन का और उसके बाद इलेक्शन करा. Let the management be let the committee be managed by someone who is neutral. Someone who is neutral. SDM को लिखा दो. Yes, please, Tulsa. हाँ है क्या? What is the matter? Okay, let the counsel for the petitioner prays for an adjournment. List in due course. Due course. Mr. ये क्या सर? मिस्टर संजीव भूषण. अच्छा ये वो वाला है, टायर वाला. हाँ वेडनेसडे किया आपने कुछ इंस्ट्रक्शंस दी? हाँ लेकिन अभी द लर्नेड काउंसिल इज नॉट हियर. इफ इट इज अ मैटर ऑफ फैक्ट कि ये लोग बेचारे पंचर लगाते हैं तो पहली मंजिल पे कौन गाड़ी लेकर जाएगा पंचर लगाने? हाँ यार नीचे वो लगाओ बड़े बड़े जैक. ठीक है. On the request of learned additional advocate journalist on Wednesday to enable him to have instruction in terms of the procedures. Next, hearing. Sir, hearing. All the learned counsels are praying for adjournment. Actual date नहीं मिलेगा. नहीं. अब जुलाई अगस्त. हाँ. हाँ. कौन सी वाली केस, कौन सा वाली केस? देखते हैं। Don't worry, I'll just. मेरे को याद नहीं आ रहा है. I'll just. Mr. Bhushan, they say that listed on Wednesday we have taken up the matter with the authority. They are consulting Rohit Shetty. Don't worry. They said he has made a statement that they are consulting Rohit Shetty. कौन सी केस में? आप ऐसे करो ना, आई सिंपली मैं वेडनेसडे को रख रहा हूँ, यू टेक स्टेप्स, आप फाइल कर देना अगली डेट पे। हाँ तो अगली डेट पे मैं कॉग्निजेंस ऐसे लिखना, एट दिस स्टेज सीनियर काउंसिल फॉर द पिटिशनर सबमिट दैट एज पर हिज इंस्ट्रक्शंस कॉस्ट टाइटल हैज बिकम डिफेक्टिव ऑन अकाउंट ऑफ द डेथ ऑफ पिटिशनर नंबर 2. He prays for and is allowed to take. He prays for and is allowed. In the interregnum, in case the legal representative of deceased petitioner number 2 so desire, they may move an appropriate application. Just 1 minute, Mr. Khitta is there. I am hearing this. Just wait for 1 minute. विक्रांत ये क्या है? ओ अच्छा, ये बताओ जरा है क्या करना? हाँ मेरे हाँ अफेयर हो रहे थे है ना, लिस्ट में फोन लगा दे। नो आपको चीफ साहब को रिक्वेस्ट कर लो या नीचे से बोल के इनको कहना रजिस्ट्री वालों को लगा देना। आई वॉज हैविंग दिस तभी लिस्ट पे फोन लगा। यस मैम। हाँ show me your case, show me that case, बताओ। You are respondent, stay आपको दिया हुआ। Where is Mr. Mahajan, Janesh Mahajan? जुलाई की लेना तो ये आप आ गए इसमें, बताओ जी। just 1 minute, just 1 minute, just 1 minute. मंडे को नहीं करना, छुट्टियों के इमीडिएटली बाद में, आफ्टर द हॉलीडेज। यस हाँ डेट देंगे। हाँ 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 रख दो, अपनी पहले कॉस्ट जमा कराएंगे 1 लाख रुपए। हैं हैं कौन? नो आई हैव इम्पोज्ड कॉस्ट, यू हैव टू पे कॉस्ट फर्स्ट। नहीं आपकी वजह से नहीं आई, यू सी आप क्लाइंट के कहने पे आपने स्टेटमेंट दी, ठीक है ना, क्लाइंट के कहने पे स्टेटमेंट दिया है, उनको भुगतना पड़ेगा, ये नहीं है। यू कांट गो स्कॉट फ्री बाय मेकिंग फॉल्स। मैं सरकार को अगर तलखी कर सकता है कोर्ट, तो पिटिशनर को भी तलखी करेगा। इट इज नॉट एज इफ देयर इज सम एनिमोसिटी बिटवीन द गवर्नमेंट एंड द कोर्ट। ओनली थिंग इज दैट गवर्नमेंट इज द बिगेस्ट लिटिगेंट, नंबर 1, एंड दे हैव अ मशीनरी इन ऑर्डर। इसलिए गवर्नमेंट कोर्ट एक्सपेक्ट्स कि इनकी जो रिप्रेजेंटेशन होगी या इनका जो एक